Okay. Something happened. Good morning again, everybody. It is 10:30. We're going to continue our briefing with community development.
Okay.
Kell, what you got for us?
Well, I'm just asking that you guys place on the action agenda, or I guess on the next Tuesday meeting, for Luke or myself to read a news release for Historic Preservation Commission open positions.
So our next meeting or not tomorrow's? But then
I think it is for the 6th. Is that the next, the two?
That's for the 6th.
6th,
Okay.
yeah.
Perfect.
Yeah.
Commissioners?
I don't know.
I know,
We have
For
so
all
much
I
we
know,
can't
it's-
handle at once.
real controversial.
Yeah, I think I can deal with that one.
Okay, thanks. Twist your arms.
Okay, anything for Kell?
I'll be back at 12:15.
Yeah, you will. For TOPE.
You still need me there tonight?
Yeah, if you wanna be there tonight, the PAC, yeah, I will say that, at Planning Advisory Commission meeting tonight, they held their public hearing and took public testimony on the September 15th meeting. And so tonight they are deliberating and making a recommendation, even if it may be recommending not to adopt at this time or take more time or what have you. I'm not exactly sure how it's gonna go, but that's tonight.
I just asked if they request for non-adoption, that they give us a list of the things that we need so that we can separate out the stuff that may be already done
Okay,
and focus on the stuff that is not. And
okay. Yep. All right.
Will do. Thank you. See
See
you.
see you later.
See you soon.
Yep.
12:15.
Okay.
Okay. Do we have Dave?
See if he's out here.
Okay.
There's no Dave, there's no Melissa.
Oh, it's all in.
All me.
Come on up.
There you go.
Sorry.
No Dave or Melissa?
No Dave or Melissa.
It's okay, you didn't tip the table over, so.
Came close though.
All right,
So, we have, first off, we have an item from Dave, which is a Board of Health application from Jody Coate. That's how it's pronounced. The board's options are to discuss, maybe interview. It's up to you.
Yeah.
We only have one applicant.
Just one applicant right now. And I believe this is for the user of public health position, I think. I'm not 100% sure about that.
Commissioners, do you want to interview? I don't know that I know Jody.
but let's meet her. That's the hardest stuff.
Yeah. If you could have
Seven.
somebody set up an interview, that would be great.
Yeah,
Yeah, I would say it's with a Cody, or Cote. Since there's a accent on the E.
yeah, I wasn't sure if that was a typo or if that's real.
Yeah.
Oh, it's on the application too. Yeah,
That's
so
what,
it's
I was
Cote.
just guessing, but
yeah.
How do you get one on your computer though?
it's a alt. Then you can
Special
You can
thing.
set it under.
I've never found it to use it, so.
Yeah, you have to know the ASCII codes.
It's easier to do on your phone. You pull your finger down on the particular, like an E, it'll pop
Oh,
up all
yeah.
the different E options.
Yeah.
Yeah.
Yeah, it is a lot easier on your phone.
All right, so we'll set up an interview for that one.
Okay.
Next is also from Dave, it's opioid settlement funds. So basically, the commission just needs to set up a workshop to figure out how to spend the funds.
Now, we have people, I know, probably asked the wrong guy right now, but we have people that are coming in to ask for some of these funds pretty quick and stuff.
Yeah, I think
Is
you're
the rec-
going to have North Mason Regional Fire Authority here in just a
Yeah.
few minutes, who is going to be asking for those funds. I know the sheriff's office has requested access to some
For
of them,
Dare.
and I think in my conversations with Dave last week, he was wanting to talk to the commission about, do you just want to consider them one at a time? Do you want to have a process by which people do an RFP and then the decision is made that way? Or how do you want to do that? And I don't know that he was looking for a decision. I think he just knew that entities are going to start requesting those, and he wanted some guidance on the best path forward.
Yeah, I do think it would be good to have a process going forward.
Somewhat, but at the same time, I'd love to have some of the conversation on it, because for myself, I'd like to see running total, like, we're just guessing on some of the other stuff. I'd like to see maybe a limit on how long they can ask for something. Asking for something for 10 years isn't realistic. Asking for something for even 5 years may not be realistic. Asking for something for 2 or 3 years might be realistic. And then come back again or something. But that'd be a structure.
Yeah, I think the fire district is a 4-year,
I think it was
4-year
I
ask.
thought it was 5.
I think it's 5.
Yeah, it'd be
Yeah.
5.
Yeah, okay.
But again, I told them, I mean, I
Yeah.
liked their presentation, I told them it was of value to come in and talk to the commission, but.
Well, I absolutely love the whole thing, but
Yeah.
at the same
But
time-
that there was going to have to be a larger discussion about the
Yeah.
opioid funds in general before that decision was made, so.
Yeah.
Oh, I'll make a note of that. Just point.
That's okay, I'm just gonna put this out here.
So, I guess you might need Dave here to look at his schedule, but do you wanna set a date and time for a workshop?
Just set it up through our.
Yeah, I mean, I
That's
think
fair.
it would be worthwhile to have Dave come in so that we can talk through what he would envision the process being, so that we can, have the commission agreement on how that process should look, so that we can make a good decision about how to use those funds going forward.
Yeah, well, I think that's what he's asking, is, yeah, he wants a workshop so that
Right,
we can put together a plan and policy. Okay, I'll
Perfect,
tell him
then
to,
yes.
My problem is both of the two things we just discussed, I love a lot. So, we'll have to figure out how to do it.
okay, next one, thankfully is mine. We have, our Clean Water District Advisory Committee, we have, Arthur Whitson is a current member on the Clean Water District Advisory Committee, and he has applied to extend his service, and he actually voluntarily sent in his application without being asked to renew, so he was ahead of the game, he was a month ahead of the game. Not often that, usually it's like
happen all the
months trail off, or
Please,
or be like,
please,
hey, will you
please.
please renew it? So, that was
Still interested?
very nice, I give him a lot of credit for that.
yeah, that's cool.
Yeah.
I'm good with extending.
That's a plan.
That's it.
Okay. And then the last one is for Melissa. Last week, Melissa briefed you guys on the law enforcement diversion program, and she didn't have a subcontract done at that time, so this is the subcontract. And she's asking if you're supportive to put this on the October 14th action agenda.
But I'd like to have her come in and talk to us about it on that Monday, because I have some questions about it, and it makes, we've had history in the past where it hasn't been used, are we using it now? What's that look like? So that's something I have to ask her.
Okay, so we'll
Just
put it on the agenda for the 14th,
But
but
ask her to come.
in the intervening Monday, can we talk
Please.
about it? Okay. What I got for you for now?
Wow.
We'll talk about TOPE.
Yeah, I have a question for you. It's just, or a comment.
Sure.
I've started receiving videos from one of our problem properties of a chop shop going on.
Mhm.
So, wanted to share those with you, so,
Absolutely.
And also maybe law enforcement too.
yeah, just, it's Lansky, so.
Mhm. Is it things coming on or just vehicles being disassembled?
He was sending me still pictures
Mhm.
of things that were coming on. I said, well, that doesn't tell me anything, whether it's moving on or off the property. I can't,
Mhm.
can't tell you. So give me videos. So now I'm getting videos sent in.
Okay,
But all he's been able to share so far have been actual chopping up of vehicles.
okay. Which could be part of their disposal.
It's possible.
Yeah, but at the same
Yeah.
time, even if you're told to dispose of, you can't be chopping up vehicles and certain aspects of it because of the oil and everything else.
Well, if they drain the fluids, it's very common for people to cut up RVs, cars, trucks, all kinds of stuff to get rid of it. We see it very frequently, unfortunately. They'll have stuff and they disassemble it, they take boats apart that way. So it's not uncommon. We don't have any local rules against taking a vehicle apart to get rid of it.
If it's done legally,
Yeah,
if it's not stolen.
yeah, just as far as public health goes, the sheriff's department might have other, if you,
I was gonna say, but at
you're not
the
the
same
sheriff's
time,
department anymore.
but again, at the same time, I know there are, you can't. That becomes a different type of operation.
If it's being done as a business, is that what you're thinking of?
Well, business, or if he's making any profit off or anything else like that,
Mhm.
it's, you know, even if he's selling the parts.
Mhm.
I'm just saying, I know that there are ones you can't do that, so maybe we can look at that, and if you can help us to figure out who we'd be talking to if those are violating the laws, we need to figure that out.
I think the challenge is from an enforcement perspective. I mean, if we want him to be cleaning the property and they're disposing of those vehicles in order to clean up the property, that's a different thing than if they're bringing vehicles in to chop them up to make money off the parts, you know, make money off the scrap, those kind of things. The thing that we have not been able to gather evidence on is that they actually are bringing vehicles there to do that. So while the activity of breaking them down in order to get rid of them, that may actually be in compliance with what the health department's trying to get them to do.
Clean
And
it up.
we would have to distinguish between the two in order to take any enforcement action. I think that's the challenge.
Yeah, that was kind of my point, is
Yeah.
from public health perspective, if the vehicles are being disassembled and taken off site, that's a good thing, as long as they're not bringing more vehicles on.
It's not like that's the only option though, because the way it works is, and I know this, I had a fire on my property many years ago, I had to dispose of 100 and some odd cars. When we did that, we paid, or got paid at different times, depending on the vehicle, they would come, they'd pick them up and take them and disassemble them somewhere else. We wouldn't let them disassemble them on our property. They'll pay him to come and get them. So, I don't know, I just know that the neighbors are worried about those chemicals, stuff like that. Even if the reason is to get rid of them, there's other ways to do it than just to disassemble them, because mistakes do happen. Coolant gets onto the ground, oil, fuel.
Yeah, we're closely monitoring those properties. We're there very frequently. The only one that had illegal disposal things going on with like ground contamination, that one has very little activity on. The one that has the majority of the vehicles has no evidence of any misdisposal of liquid that we've seen, and that usually causes a lack of vegetation growth, kind of like a brownfields effect. So we haven't seen anything like that. Doesn't mean something like that hasn't happened at the moment. It's definitely something we're typically concerned about and look for whenever there's any kind of vehicle issue with those fluids and where they're going.
Now, taking on this property, we've gone and taken an assessment of what's already there, so if another vehicle shows up with a license plate, and that happens to be one of the pictures, we should probably know that too.
Yeah, we're closely watching the number of vehicles they have, which vehicles they have. We've walked the property with the owner and cataloged the vehicles that are there. So there shouldn't be more vehicles. They've been told that if more vehicles show up, then code enforcement action will escalate versus being in more of a steady compliance mode.
I'll send you the links to the videos, so.
Yeah, absolutely. Also, the other thing I can say about both of those properties is the sheriff's department is making their presence known by making visits and talking to them. So for them to suddenly be in a new illegal activity like chop shop operation, that would be the smartest thing for them to do. So I would hope maybe that would also help deter illegal activities like that.
Just for clarification, I don't think they're turning their chop shop. I think that they may be disassembling vehicles, and that's a thing that's just not done on residential property on a large scale without great risk, and that's why we don't allow that on properties.
Yeah, and we might be able to get Kell involved if they are doing something that they're not allowed to do there, but I think for the most part, if they're getting rid of the vehicles, as long as they're not running it as a business, yeah, it's definitely something to look into. Any other topics or anything?
No, that came in on Friday, so
Alright.
video, so actually Saturday.
Are you gonna do it on TOPE?
TOPE is scheduled for 12:15, so
You'll be here for that.
I'll be here. I don't know how long it's gonna be, so I might just hang around.
Can I ask you if we can take a look and see, because one of the questions I'll ask today is for you to show me where it says they cannot do it.
That's a Kell question.
Yeah.
So I would ask that of Kell. I don't know that much about the
I'll
zoning.
try to get a hold of her, you know, but what is it, the law that actually says they're not allowed to have these parties and stuff on their property?
I'll send her a note
Please.
while I'm here. And
Appreciate
try to get her, so she has her look at that.
All right, do we have Angela out there? We're a little early, but. No? Well, she's scheduled at 10:55.
That's probably, do you want to swap with North Mason, who is here?
Sure, you guys okay with that?
Yep.
Oh.
Never mind.
No. And they're here,
Right to the
Morning.
table.
yeah.
This table here?
Come to the center, Mario.
I'm Angela at Avery. I have a slideshow for you guys, so let me just get that pulled up. Is Christopher here?
No.
I just am wondering how I should put the slideshow in.
Oh,
Oh, we can share this screen.
is it on like a thumb drive or?
I can show you on my laptop, I'm happy to do that too. It is on a thumb drive.
I am not a tech guy.
No, but if you go
Tammy,
into,
do
if you go into Zoom, you'll be able to share right from your screen.
So put it in your guys' computer?
No, just go on to Zoom,
Just go on to
sign
Zoom.
on to Zoom.
Gotcha, okay.
Here's your drive.
Not bad, I came up last night.
Oh,
Yeah,
even better.
I wanted to be fresh
So
for
skip
the
the
presentation. Yeah. Yesterday was a beautiful drive with the nice weather.
All right, it was a beautiful day.
Just looking for a toggle. Alright.
And where will she find the web link or the link to?
Meeting page of the county website.
Is it? I'm there. I don't see it.
Scroll down to the calendar.
Oh,
Should say the date with the.
Yeah, we need to have that just as a bullet from now on. If you could have IT, there should be, every time we have a meeting, it should be right there on the top of that website.
It is on the main page.
Commissioner
say it
briefing
is.
29th.
Uh-huh.
look at that. Hidden in plain sight.
It's right there.
Alright. And then I think somebody's gonna have to allow me to share my screen.
You're allowed.
Granted.
Alright, well, I'm just gonna do it, instead of the thumb drive, I'm just gonna do it from where I've been working.
Sounds good. Wherever you like is great.
Thank you. Alright, so, I put this presentation together for you guys, to talk about the new standards of public defense that have been implemented by the Washington State Supreme Court. Ms. Truss knows me, but for those that don't, this is me and my family at dinner a couple weeks ago when it was not raining. My mom's there in the back. So what I'm doing here for the county is I've been a contract attorney for two and a half years. I have really serious felony cases, primarily murder, serious assault, that sort of thing. I'm a former deputy prosecutor, that's how I started my career. And I own my own law firm in Vancouver, and then right now, I'm a contracted chief public defender for Mason County, so I fill in Peter until at least December 31st. So again, presenting on the new caseload standards. It was a little bit challenging to synthesize a 168-page report. These are the new This is a RAND study that was done, that the Washington State Supreme Court adopted. So not everything is in here, but I did my best to, mostly what I gave you guys is numbers, budget numbers.
That's good, because that's a lot of reading.
Right. This is just a copy of the Washington State Supreme Court order that changed the standards of indigent defense. So big picture, what we're looking at is, right now there are standards of indigent defense. Those allow for a felony public defender, county attorney to take 150 felony cases per year. That's what's allowed by the standards. And then misdemeanor attorneys in district court are taking 300 to 400 cases per year, if that amount is filed. So in June, the Washington State Supreme Court said, no, you guys can't take that many cases because you're not providing effective representation because of the number of cases and the complexity of the cases. So this summarizes the Supreme Court order. It's only 4 pages long. But what we're going to be required to do as a county is reduce the number of cases that our county public defenders are working. The Supreme Court has given us 10 years to do that, till 2036, but they also said it must be accomplished as soon as reasonably possible. And over the next 10 years, they want us to reduce the caseloads by 10% each year. So 150 cases down to 135 for felonies just for the first year. Even though they gave us 10 years to do it, they're going to check on our progress in 2029. So what I'm here to tell you guys and ask for today is ask to implement the whole 10-year standard now. And there's several reasons for that. And I also did my best with math, which is I'm not good at, to find out what is that going to cost the county. So either we take 10 years and we do it, or we do it now, and hypothetically the budget pain is a little less if we do it now. By law, by the Constitution, effective public defenders are required. So it's the United States Constitution, the Washington State Constitution, court rules, the rules that license us as attorneys require that we do an effective job. The standards of indigent defense, and then the rules of professional conduct. Those are the rules that require us that we have to follow as attorneys to keep our law license. So this is where I was saying previously, from 1984 until 2025, a felony attorney is allowed to take, these are guidelines, not strict law, but allowed to take 150 cases per year per defense attorney, and then 300 to 400 cases per year in district court. This obviously was before the advent of technology that exists today on each of our cases. The number one thing I think of here is body camera footage. Did not exist in 1984. It takes hours and hours and hours for defense attorneys to go through, and frankly, prosecutors to go through. But we have to go through it to effectively represent our clients. These are the new standards, just a different graphic. I like mixed visuals. So going forward, at the end of that 10-year period, each county attorney that works in public defense is only going to be able to work 47 superior court cases per year. Per public defender, so that's a 2/3 reduction. And then same for district court, 120 district court cases per year per public defender. This is the front page of the RAND study. So what the Washington Supreme Court said was our attorneys are leaving public defense in droves in Washington state. They're not happy with their workload, and we can't even get people coming out of law school to go into public defense. And the big reason for that, one of them is the pay, and one of them is the workload. Public defenders are burning out. Public defenders with 10, 15, 20 years of experience are burning out, And then we lose that institutional knowledge that are training the younger attorneys that are in the office. So what the RAND study is the RAND group studied 22 different jurisdictions across the United States, including Oregon. There's been critique on this study that, well, they didn't come to Washington. But if you read, and I don't like statistics, but if you read how they did the statistical analysis in this, what they did is they studied other studies. It's called a macro study, and they studied other studies that have been done across the United States throughout the different years, and they condensed all those studies that have been done across the US and put these numbers out. In the RAND study, which is what I'm going to be quoting to a lot, there's 8 things that are required by county defense attorneys to do a good job for their clients, to meet the standards in that rainbow color slide. The first 4 are here. I would say client communication and care is probably the number 1 thing that defense attorneys do. People that come across misdemeanor court, come through district court, they're still voters, they're still taxpayers. They haven't lost the right to vote like some of our felony clients. DUI is the number 1 I think of in misdemeanor court, district court. It's very common for many people to have that across the spectrum of income, employment, immigration status. It's one that really gets many, many people. And then the second slide here is just the other 4 categories of work that we do as public defenders. So the RAND study spends a lot of time on saying that all cases are not created equal. Murder cases are not the same as DUI cases. That's pretty understandable. But they did give us a number of hours that each type of case takes to work. So superior court attorneys can go down to district court and work district court cases, but meaning I could go work a DUI case as somebody that takes frequent murder cases, but it's not the other way around. District court attorneys cannot work in superior court until they're qualified to do so. One of the ways they get qualified to do so is to do a number of trials in felony court and superior court. Right now we have an attorney that is just switched up to superior court, and she can only take nonviolent offenses. So she's not qualified to work all the superior court cases yet.
And Angela, to become qualified, they work underneath a qualified attorney, is that correct?
Yeah, they would do X amount of trials. I think it's at least 3 felony trials as second chair, meaning they're not the primary attorney, they're the secondary attorney. That's just to get qualified. To be good at it, that takes even longer. These are the standards that I was referencing just now, how you become Class A qualified. I've done about 150 trials, so I'm Class A qualified. I can take life without parole cases, meaning 3 strikes and you're out. The attorney I was referencing cannot. She can do stolen cars, felony harassment, lower level crimes with less punishment. So I went and pulled Mason County's numbers from the Administrative Office of the Courts to find out what kind of cases are we looking at in Mason County and how many attorneys are we going to need to work these cases. So that number is not my number. That's the county clerk's reporting to Olympia. And 2024 was the last number that was done. In 2024, there were 7 murders, 72 assaults, and you can read on from there. So then I asked Human Resources for what does it cost for us to have a county attorney in the public defense office. So I got a spreadsheet that I didn't quite understand. I wish Human Resources could have reviewed this. I didn't ask them to. But basically what I did was I added up the benefits and salary for each attorney and how much experience they have. So the average salary for county attorneys in the public defender's office is $114,000 per year. Right now, we have 5 active attorneys, but the average number of years of experience is 18 years. So an attorney with 18 years average of experience is making average of $114,000. That's not where I was going with this slide, but I do want to point out that almost all of the attorneys on this slide live in Mason County. They're voters here, they pay into the taxes here, property taxes, and they contribute to their salaries. So I, again, got from Public Human Resources all the benefits that each county attorney gets. And again, this is me doing math, there may be mistakes in there. So to have a county attorney working in the public defense office is about $154,000. So we have, then the numbers I put in are how many attorneys do we need to work those 230 felony cases in Mason County with 2024 as an example year. I have that number in just a minute, but based on the RAND study, this is what they estimate it takes to work a felony case. That first top number is a life without parole case. Each felony attorney, if they are working a life without parole case exclusively, should only take 7 cases per year because it takes 286 hours to work that case. And there's a number at the bottom that's important on this slide. They're using an average number of how many hours per year a person is working. So they averaged 40 hours a week times 52 weeks in a year. That gives us the 2,080. And that is if an attorney is working every single minute they're at work and don't take a vacation, don't take a lunch, etc. So what I want to point out on this slide is we can assign one county attorney all 8 murder cases at 248 hours a case, but that's all they're going to be able to work. What most people prefer to do and what most counties do is mix it up. So we would give a felony attorney some felony lows, maybe 10, 20 of those, maybe 1 or 2 murders, maybe 1 or 2 sex crimes. But the point here is, again, not all 47 cases of felony. Knock on wood, that never happens.
Please no.
2012 all over again.
So again, using the math, I think it's going to take about 5 felony attorneys to fill the new standards. 47 cases per year times or divided by the 230 cases in Mason County that were filed. So I did full-time employees times 5 attorneys to work those, just the felony cases. And so my estimate is that it's going to cost $773,000, including payroll and benefits, to implement the standards for Supreme Court or Superior Court, meaning felony cases, the most serious cases we have in the county. Okay, so kind of the same conversation about district court cases. It's nearly impossible. I've done district court cases. That was this first 2 years I was a deputy prosecutor. The second 2 I was a district court attorney, and I had 300 to 400 clients. It's hard to know your clients' names, their cases. Support staff puts their calendar on the case on the calendar, but you're just running yourself ragged if you're working 300 or 400 cases. The Supreme Court of Washington recognized that, and so they're asking us to go down to 120 cases per year. So again, I pulled the numbers from Mason County District Court. These are not my numbers. They're reported to the Administrative Office of the Court. We call it AOC. So DUIs, just 268, just in 2024. And then district court cases filed. I took the Shelton municipal court cases out. We're not working those, but 665 cases per year. So simple math right now, that would take about 3 attorneys, but we're going down. The standards are asking us to go down.
So Angela, are these numbers, I'm sorry, are these numbers public defender numbers or total numbers?
These are numbers filed with the court, or filed by the prosecutor's office, so these get filed by the prosecutor's office. The court gets the filings, and the court reports the numbers to AOC, to Olympia. So these are filed cases. Doesn't mean they all go all the way through. It doesn't mean all 665 end with a sentence or a diversion or anything like that. But that's what's been filed. That's what was filed in
Okay.
district court.
Not all of them are public defense cases.
Thank you.
That was,
Thank you.
That I wouldn't be able to know by those numbers unless I went through all of the public defense office numbers.
Right,
Well, we know that not every case is a
Yes.
public defender case, we know that.
right.
Again, the column I'd like you guys to focus on here is the 2080 at the top, and then go down below that. That's again assuming a public defender works 40 hours a week, 52 weeks a year. So DUI, and these categories are just how complicated are these cases. DUI high is a more complicated DUI case than a DUI low. One of the things that comes up a lot, especially right now for DUIs, is a lot of these are blood draw cases, meaning they're thought to have drugs in their system. We can't do that or figure out if they're intoxicated via a portable breath test. So the police send the blood to the lab, and it's taking a year or more to get blood results back from the lab. That's a statewide funding issue, luckily not our issue that we have to deal with, but it does impact cases. So again, just like felony court, we can't expect a public defender to take just DUI cases, or we're not set up to do that. But if they did, they could only take 63 of them, so it would be half their caseload. What we would like to see, and what we do is mix up DUIs with some assaults, with some reckless drivings. Probation violations are pretty easy to work. It's somebody that doesn't do their community service hours, and they get in trouble for that. So based on all of these numbers, 665 cases a year, 120 cases per attorney. We would need 5.5 county attorneys. I think we could find a part-time attorney if we wanted to. There's always somebody that would rather work part-time. But the cost to the county, I think that bottom category should say, no, it's 5.5, okay. So cost to the county, again, assuming average 154,000 for each attorney, is gonna be 850,000. So then I did the math for us, because I'm not good at it and couldn't do it on the fly. That would be $1.6 million just for attorneys. And again, the question that I'm asking is, do we do it now and feel the pain now when payroll is cheaper, when health insurance is cheaper, salaries are lower? If we hire somebody 8 years from now, their salary is not gonna be $114,000. So we need 10.5 attorneys to work these new standards for the public, the Washington State Supreme Court is imposing or adopted.
So can I ask just a
Sure.
clarifying question? The number of cases, are those the numbers that OAC went with the total number of cases, not the total number of public defender cases?
The court reporting system itself, or the Washington State Supreme Court?
When AOC came up with their guidelines, were they going on total number, or were they going on total number of public defender cases?
They were going on how long does it take an attorney to work a case, more so.
Okay.
Yeah. And based on, if it takes 286 hours to work a case, it's more so how much time does a county attorney humanly have possible to work a case and do a good job. It's not even a good job, it's a meets minimum standards job. There are what we call IAC claims, ineffective assistance of counsel, meaning the attorney didn't do a good enough job, and a lot of time they don't do a good enough job because they were too busy working 150 cases at a time rather than 47. Does that answer your question? It's based on the number of hours it takes to work a case.
Yeah.
Not necessarily how many attorneys are available.
Got it.
Okay.
Thank you.
Madam Chair?
Sure.
Some of the stuff I'm trying to figure out, I've read and gone through this, but there's a few things that aren't quite meshing with me. I don't see 47 cases, I see credits and waiting.
Yeah, that's true.
And if you don't weight these, then how would we hire just on 47? That doesn't compute for me, or 120. Also, so that would change everything, but we also contract with attorneys. If we started to put a limit on now on the ones we contract with, they can just go off and still work somewhere else and do some other stuff. I don't see how that would benefit us at all. And the third part I wanted to bring up is I understand the argument on paying today versus paying in 8 years, but as somebody that we do union contracts all the time, I can assure you, in 8 years, we're gonna pay them what they're being paid, supposed to be paid in 8 years.
Yeah.
That doesn't change. So I just wanted to throw those things out to you. I appreciate the work that you've done, but those are some serious things that are hanging over, looking at these numbers and looking at the dollar amount. I'd like to see where the benefit is for doing something like this early. That would be an argument I'd like to hear. And I can see where one of them would be that you can actually get attorneys where you may not be able to get them in the future. I can see all that. But then I would also like to ask, does that mean that we should also be looking at waiting how much we pay out on contracts, if we can get them on contracts?
So I address a couple of those things in a couple more slides. So I address contract attorneys, and I address what other counties are doing, and we are going to have to, that's the point of my future slide on what other counties are doing. We're competing with the same pool of attorneys in the entire state of Washington. That is a benefit if we implement those standards now. If we can say, we are already implementing these standards, we're not gonna bog you down right out of law school with 300 to 400 cases at a time, come work for us, because we're only gonna give you 120. We don't have to do it right now, but we're going to do that because we want you to come and work for us. So that's one of the benefits of doing that right now. It makes us more competitive because our pay is not competitive compared to other counties. And I brought a couple examples of that with me. Case waiting, the reason I didn't go too much into case waiting is because it's probably half of the RAND study. But I completely agree with you. Not all cases are created equal. And 47 cases doesn't mean we have to stick straight to that number. If we want somebody just to work low-level felonies like felony harassment, they can certainly take 60, 75 cases. We just have to be as compliant as possible as our own. I have to be compliant with the rules as a contracted attorney, and then our office has to help our attorneys be compliant with those rules too, because it's not just our law licenses. That's a big concern for us as attorneys, but it's also that, again, rainbow colored slide, the county is required to follow all of those rules. And I should have said at the outset, I fully recognize this as an unfunded mandate. There's a lawsuit that's going on through the Washington Counties Association. That's still going. That may change everything, and I may just have to delete the slide at that, depending on what the result, or the slideshow, depending on the result of that lawsuit. This is what we're stuck with for right now. And then as far as contract attorneys, you're completely right. They may work 47 cases here, and then go work also at the same time 47 cases in Thurston County. That's on them to comply with their licensing requirement. I have to comply with this rule as a contract attorney, and every single contract attorney that's in Superior Court right now doing cases, they also have to comply with it. We don't have to report these numbers to the bar though.
But with that being said, that means that it's 10% off of what we have for this year, which means that that's 10% off with waiting cases, which allows, once we establish what the weights are, allows us to expand on those numbers again.
Yeah.
It's just, there's a lot of money difference when we're talking, but it's not even just the money. I remember Peter Jones said something to me that stuck with me. One time I questioned him on their work levels and how much work that they have to do. And him being a public defender, I expected a different answer, but he gave me an answer that was very honest. He says, Randy, sometimes it is very simple to just plea out, not because we're just trying to get out of the work. Number one, they were arrested. Number two, they probably had a witness. Number three, they may have had it on videotape. Number four, there's a good chance they were guilty.
Yeah.
And so the best thing we can do is to get them out of it as much as we can.
Yeah,
And with that being said, that's another reason for waiting, because, waiting as in wait.
Yeah.
Not waiting.
uh-huh,
Because this way, if they do plea bargain out, it doesn't mean they hurt their client, they did the best they could with what they
Yeah.
actually had,
Yeah.
and that may have been this much compared to,
that's completely accurate. I've had clients where I go and see them in the jail and let's say it's a serious assault case, get me out of jail as quick as possible, I
Yeah.
wanna go to prison because they hate county jail. And they don't take the whole 225 hours to work
Yeah.
those cases, I agree. This is just a guideline, or we had to quantify it, the Brainiac statistic people had to quantify a number for working cases and how long does it take. So I agree with you, if I got that guy the assault too, and he just wants to plead out as soon as possible, and I don't have to do any interviews, and I resolve his case in 2 months, something like that, that absolutely allows for me to take more than, over that 47 amount of cases, take more than 47 cases, it does.
There would almost have to be a dedicated person keeping track of that.
well, that's the problem that I'm actually bringing up, because I do know that we can't wait the cases until we actually wait them.
Right.
Yeah,
We have to do the work and establish what that looks like, to actually weight them and how to quantify it. I know Peter had done some work on that, I don't know whatever happened with any of that work, but I do know that the work was being done at the time. I was following and working with, this whole thing has been over the top of our heads for a while.
let me see if, this slide right here, it's what King County is doing, and nobody wants to hear about King County, I recognize that, it is not Mason County at all.
At all.
But one of the things, it says felony cases are assigned 1 to 8 credits based on seriousness. That's in the second non-bolded paragraph. And so that is, again, one of the limitations of my slideshow, which is I didn't put a lot of this stuff in here. I just wanted to give a treetop view of what's happening, what's coming, so you guys can make the best decision for the county. But I've asked other chief public defenders, what are you guys doing for case weighting? And most of them have said and this is Clark County, Thurston County that I've talked to. I reached out to Grays, but they didn't get back to me. They're adopting the case weighting standards that's in this RAND study, because I don't think, for lots of reasons, but one of the reasons is none of us want to reinvent the wheel. So if I say an assault 2, which is like an assault strangulation, is 4 credits, that's absolutely going to make a difference as to how many more credits or cases can any public defender take in Superior Court.
Especially if we set those rates today, which is what you're asking though, right?
I'm more so asking for the attorneys to work these cases, but that's how I get the number of attorneys that I work, or that I need to work these cases, is how are we gonna do case weighting? That's absolutely accurate.
I believe Kitsap has also adopted
The RAND
the
numbers.
rate.
Just to go back, and I'm happy to keep answering questions. Right now, we have 3 vacancies. Chief Public Defender, that's been open for almost a year. A District Court Attorney, the pay rate for that compared to other counties is low. That's not the topic of my discussion today, so I'm not weighing in on that. However, that's the salary, and then Legal Secretary position is open as well. We just did a second interview with somebody in that position, and I don't know if she did accept that. So that's the person that works at the front desk at the Public Defender's Office.
So I'm gonna say something that's based on my internal belief, not. I have a hard time with the idea of somebody that's become attorney, did all the work to get paid what they're paid. I do think as a person, because they have more value than I do. But with that also being said, we went through a whole process, and we actually did accounting of what everybody was paid within our comparables, even expanded our comparables. So it isn't that we just chose a number randomly and they were underpaid. We actually tried to make sure they were paid in the upper echelon, even though we fall in the mid-range. So I don't know what you based yours on, but I also know that, just to share with you, for the future, when we're talking about these numbers, we need to find out what the actual cost is, because for us, if somebody's making $117,000, it's not a $150,000 employee, because it's more than 40,000, yeah, or 30,000 to have them. It's a lot more for us, between L&I and their medical and everything else that we're offering. It's a lot more.
I put that in my slide, because I got those numbers.
Yeah, I know you did.
Okay,
I was just telling you, there's
It's
some
about
parts,
30%.
there's some parts, yeah.
okay. So I'm not at all knocking what you guys pay, the district court attorney. The reason I bring that up is because I brought comparisons as to what whether other counties are paying their attorneys, to highlight, again, this is the pool we're trying to attract to Mason County. If an attorney right out of law school can go and work for King County for $103,000, that's what I have highlighted here, they're going to potentially go to King County. I like working here for several reasons. It's beautiful every time I drive up the highway. I love working with Maggie and this dedicated group of attorneys you guys have. But when somebody has school loans and they're right out of law school and they've been broke for 3 years because it's hard to work during law school, that's a number that they're going to be considering. I also looked at other counties that have open positions. Yakima County is paying their attorneys about $100,000 a year, brand new attorneys. And then Skagit County is paying their attorneys actually a little bit more than us, but not $100,000. Close to that, but not quite. And again, I don't have any judgment about that because I'm a contract attorney, so I get paid what I get paid. But there's 3 law schools in Washington State, and if we're getting applicants mostly out of Washington, which is what we are getting them from, where we are getting them from, they're going to be, one of the things they're going to be considering is salary. That was just a breakout of that King County slide. Okay, so I anticipated one of the questions would be, why don't we just give everything to contract attorneys? My answer to that is, it's not gonna save the county any money. Right now, you can see I'm working new cases I've got since May 2025, I'm making $175 an hour. If you times that, a lock case, a life without parole, 286 hours, that's a lot of money. That is not something I can do on the fly. But I think I have an example in here of what that might cost the county. District court attorneys, we can't get them. We can't get contractors for district court. We're having a very hard time doing that for a number of reasons. Maggie is trying her very, very best. I think we've gotten 1 or 2 recently.
Make sure you give her a pat on the back from us, please.
I bought her lunch last week too.
But I mean, if you're done, talking to her boss, I'm telling you, she's extremely well respected in our realm here.
I'm glad.
We talk about her and hold her very, very, very high regard.
Yes, yeah, and
So I
she's
share that.
always on the run. Thank you for sharing that. So this is longer, this is meant for you guys to read later, but last year I had a life without parole murder case. My client was 45 years old. At the time, I was only billing $125 an hour. The rates have since gone up. We looked at my billing for that case, and this includes 3 weeks of trial. And I grabbed one of your guys' attorneys so she would get experience, Rose Boughton. My billing was about $57,000. And then if you times that times 2, because I snagged Rose, and you guys were paying for her so she could get experience, that one case cost $114,000 to the county. What this says is that the bottom right slide is what I want to highlight. There were 7 murders in Mason County in 2024, and if you paid contractors to work those cases at today's rates, it would cost about $558,000. But if you plug that into county attorneys that are, again, hopefully living here, paying into taxes and voting, that would give us 3.5 county attorneys. That's where I'm gonna stop with the contractor versus county attorney. That was all done before I got here, before I even started working here. We do need conflict attorneys, we do need contractors, but again, my point here is to highlight that it's not necessarily cheaper to have contract attorneys versus county attorneys. I think it goes without saying, but it would have been way harder for me to figure out these numbers. I can do that in the future if you guys would like. We need support staff for new attorneys. If we have 10.5 attorneys in the office, we need support staff to work for us. You don't want to pay an attorney, let's say $175 an hour to file a case, a document with the court. You don't want them walking across the street to file a document. We can pay somebody the $51,000 rate to go file that. It's also required by the standards of indigent defense that we have support staff and resources, including expert witnesses, forensic psychologists, investigators to work our cases. Again, I didn't even want to ask HR for those numbers, but right now we have two. We have Maggie and then we have the legal secretary. The legal secretary's also their job to answer the phone, answer clients that come in, calendar, do all sorts of work. I'm sure it's probably in the RAND study how much support staff we would need, but again, this presentation was meant to be a treetop view of what we're going to be looking at in the future. It says the exact same thing. And then just to wrap up, because I wanted to leave time for any additional questions. And I've already said this a couple times, but the RAND study, I didn't put every single thing in here. That would have bored everybody online and in person to death. It has a lot of statistics. I struggle with that. That is not my expertise, but I could look at the charts and try to plug those into this presentation and just give you guys my best view of what's coming. And I do want to highlight that this wasn't just public defense's idea. I was sitting with Mr. Dorsey and Tim, and we said, why don't we go talk to the county now about what's coming, rather than Mike had a really weird analogy, cutting off an arm and
It works.
cut off the arm now to save the body, something like that. But I do want to thank the prosecutor's office for supporting that, hey, we should have this conversation now and not in January 2026 when we're supposed to reduce the caseload by at least 10%. And that's all I have. Here's my contact information, and if you want to contact me directly, even though I live in Vancouver, I'm up here once a week or every 2 weeks to do lots of things, but work mostly.
So, yeah, I do. Where do we get the attorneys from? I mean, I just,
Yeah.
sitting here running numbers through my mind thinking, there's not enough. I mean, you talk about an attorney pool. Well, we have a kiddie pool and we need an Olympic-sized pool to fill all these positions. I mean, it's.
That's one of the, when there was public comments done to the Washington State Supreme Court when they were adopting or discussing these standards. And that's exactly what a lot of the agencies, primarily the county attorney agencies, said. These folks are retiring, people are retiring. I don't know if Ron's here. Ron is a 35-year attorney.
Super attorney. He's got a cape. I know he does.
Yeah. Attorneys are retiring. We need to plug new attorneys into those spots, but we're losing that institutional knowledge. We have the 3 law schools, and unless we change our numbers, meaning adopt these standards, I think, earlier rather than later, we're not going to get the finite amount of attorneys that want to work in public defense or even, frankly, prosecution.
But it's kind of a nationwide
It is.
problem.
Mm-hmm.
I have 6 attorneys in the family, so I get to hear about this all the time.
Yeah. There's
They're
literally.
just not graduating.
Yeah, that's exactly what I was gonna say. There's not even enough attorneys to graduate, that are graduating law school. to come and fill these spots. Despite that, the Washington State Supreme Court said we're adopting it anyway. One of the ways we can do that is to be very, very competitive, like I said, with pay, adopting the caseload standards early. This legal secretary we just got, we brought her to the office and had her tour the office, and we took her to lunch I took her to lunch because we want to sell Mason County as the amazing county it is. You have the Olympic Mountains, you have all the lakes. I think that's one of the ways we beat these more urban counties. There's also the Office of Public Defense for Washington State has a rural program. I should have put a slide in there. A rural attorney program where they'll do fellowships and put attorneys in our office. And they wanted to do Mason County last year, but they didn't have a head public defender, where they pay the salary of the public defender or the person coming out of law school, and have them work here in the community. They pay a stipend for their housing. So that program exists. It's called the STAR program. If we have a new chief public defender this next summer coming up, we will absolutely get one of those folks. So if we can have people come and tour, walk around the county, we'll take them around the county. So ultimately, we met with OPD at this first meeting we had regarding this, and OPD, Office of Public Defense, studied this. It's a statewide office that gives everybody funding to do public defense, and they said they studied, they asked attorneys, practicing attorneys, what will either keep you here or prevent you from staying in public defense, and they said caseloads and pay are the two things that they're concerned about in life. And if they don't get those things to satisfy their needs, they leave. But I agree with you, there are not enough attorneys coming out of law school to meet these requirements. So my goal, my hope is that we make ourselves as competitive as possible to get the ones that do want to come and work in public defense.
Any further questions?
Thank you guys for
I have
the
one question. So what happens in our system if we adopt the caseload standards and then we can't hire any attorneys?
That is a good question. We would have to go back to just doing the 10% per year. We wouldn't have a choice. We've been trying to hire a district court attorney since August, I think, and we've had attorneys say, yeah, I'll take the job, and then they just cancel right before they're supposed to come. I think at that point, we would just have to do the best we can each year. So if I could get a pool or a class of 5 attorneys right now, starting in 2026, then we've met our burden and our standards. But if we don't, then we are gonna have to just do the 10% per year. And even that right now is challenging because I can't get an attorney in the office. I don't think it's us. I think, frankly, I think it's a generational issue. And I'm not 25, just now coming out of law school, but I do think it is a generational issue. When committing and saying, hey, I'll go work for you, and then not actually showing up, so.
Well, that's why I asked the questions, because
Yeah.
I mean, if we're talking about adopting the standards all at once, but then we can't hire attorneys now.
Yeah.
You know, then, you know, what happens to the rest of the system if we can't assign, you know, a
Yeah,
quarter
he
of
was
the caseload
asking-
that we did before.
He was asking it backwards from what you were thinking. He's asking you, if we did it and put these standards, what kind of risk are we facing if we don't hire attorneys? Because we put those standards on, so now you have those same restrictions. That's what I was bringing up earlier with the ones you contract with. That's what my fear was, is the same thing he's.
What I had said, if I may, to Angela and Tim, at least, was more like, maybe we need to take the Civil War field physician approach and cut off the arms and legs and try to save the patient. Because I think the answer to Travis's question is, if we have to do something, and whatever it is that we're doing, if we don't have the attorneys to meet the caseload, then we're at risk of having cases dismissed. And I don't think, I looked real quick, and I apologize for grabbing it, Angela, I just thought, I couldn't remember if it was in the RAND study, I don't even know where to look. When the Bar Association had their Board of Governors meeting, they had a massive document that was led into that, a briefing and all the recommendations. And they had a full section in there dedicated to what they called unintended consequences of, you know, we recognize that there's a shortage of lawyers, and if there aren't enough, then cases won't get prosecuted, but we'll just have to address that another day. In my job, in my world, when there is a reasonably foreseeable and natural consequence of a volitional act, we don't call that unintentional, we call that intentional. So I took issue with referring to it as an unintended consequence, but it is the easily foreseeable consequence, for sure.
It's debatable whether it's unintended or intended. I
I'm
would
fully
say.
convinced that if you call it unintended and you anticipate it and you factor it into the calculus in making your decision, it's no longer unintended. You're making a decision that will reasonably and naturally, from which will flow this result, that you can't hardly say that's an unintended consequence.
But I also think too, with this further discussion, if I can advertise on the job posting for district court attorney and say we do need more superior court attorneys, we have implemented the standards now, and you're only gonna get 47, depending on case weighting, cases per year. That checks one of the boxes that OPD told us is concerning to attorneys. It checks the box of, what is my case gonna look like when I go there? I don't wanna work 300 to 400 district court cases a year, but I can do 120 and still raise my kids and still take vacation and still go to the dentist. I think that would, if I could do that now on our postings, that would attract a talent pool that we don't quite have yet.
When I spoke with Kitsap, I asked them that question, because they had implemented, and they said that they were still having issues or problems getting attorneys, because they're just not there.
Yeah. Yeah, we definitely can't make them appear out of thin air, to your point, yeah.
Yeah, yeah. Well, I think that this,
apologize, it's not my intent to, this is a miserable decision, there's no good options. When I say what I said, it really is from a standpoint of, maybe that's the best way to keep what we have at least, and not lose to the vacuum to surrounding counties that are going the full weight. Because I worry also that if we slow roll it, that we're gonna lose what we have.
Sure.
And I don't think, and I don't know, Angela, you said something, I did have a question about they can do 47 cases here and then 47 cases in Thurston County. I think if they do that, they're violating.
They're violating the rules and their
Right, I mean,
law license
I
requirements.
understood that that's not on you if they do that.
No.
But they actually can't do that, right?
They're not supposed to.
Right,
They wouldn't be able to sign that certification.
right. They could not certify they were in compliance with the rule if they were doing
Right.
that, because it goes by pro rata, how much of your practice is dedicated to public defense, I think.
Sign with who?
What's that?
Sign with who, that they weren't following the rule?
They have to sign you know.
Yeah, we have to sign
a certification saying I'm in compliance with the case standards.
But the case standards are only gonna be down 10%.
Whatever the standards are, they
Yeah,
have
so
to say
that,
they're in compliance with it.
that's still though, they could still do, if we're saying we're going to 47, doesn't mean that they are.
Correct.
Yeah,
Sure.
Yeah. Good, and for lots of reasons. But one, maybe most of our contractors are solo practitioners, meaning we pay their income. I think that's not quite the issue, but,
Well, actually, that brings up another question. We have contracts, and if we limit them to 47, do we all of a sudden find out that we need more contracts?
that's one of those unintended consequences that.
Not unintended, if we do have
Right.
purpose going in.
And I'm guessing Mike is thinking like the elements of a crime, because that's how we think. But that is something that if I only did contract cases, which is literally what I'm doing right now, and I could only take 47 a year, that reduces my income. And that is something that was discussed during the public comments. We may not be able to be solos anymore. We may start joining public defense offices.
I see this as like, okay, if we implement it, we went, just like you've suggested here, we went right, go to full bore, but we can't get the attorneys. Do we all of a sudden not have, I mean, you only have to do the 47 cases, but we can't, we had one or two attorneys. All of a sudden, we've now said, okay, well, we can't prosecute cases because we also can't provide public defense based on instantly going to the standard.
On our
So,
own.
That's the cliff we're headed towards, yes.
yeah,
But do we bring it upon ourselves quicker if we are
Yeah,
the ones that
that's-
implement it?
that's,
We make it 47, now all of a sudden our staff can only do that, and we can't get any other attorneys.
The flip side is we don't, and they all go to the Thurstons and the Kitsapps that are, and we don't have any attorneys anyway.
But the other thing too is we run the
So
risk
it's
if,
rock and hard place for sure.
if we don't do it, and then say we say, okay, we're only gonna do the 47 cases per year, but then we still go over with what we're assigning to our public defenders, our clients can sue us. Our clients can sue the county and say, hey, I'm not getting effective representation. Let me do a public disclosure request. That one attorney still has 75 cases. I'm gonna sue you guys. You haven't given me enough attention, enough of your time, and you're not following the standards. Rock and a hard place is accurate.
I'm gonna have to close
I-
this.
Sure.
I wonder
this
what,
one,
I
but-
wonder what it's gonna mean for flat out, don't do any public defense private attorneys and how
It's entirely possible.
that
Yeah,
can be used to analogize the same ineffective claim.
yeah. But-
Thank you again for your time. It was a
Thank you.
pleasure to meet
Thank you.
you and see Sharon again.
Yes. And thank you for putting all of this information together.
Yeah, no problem. I learned a lot by doing it.
I bet, yeah, yeah, it was great information.
Folks,
And the conversation continues.
It does.
do you have a minute on the way out, Angela?
Sure.
Thank you, Maggie.
you get 47 minutes. That's it.
I'd rather take 47 cases.
Yeah, for sure.
Maggie, thank you for everything. We are well aware. She keeps us.
Happy to be here.
Thank you, Maggie.
Oh, excuse me.
Hi. What's up?
Hi, guys.
Hey, how's it going? Long time no see.
Morning,
Morning, sir.
You brought the other guy?
Or did I bring
He
you?
brought me.
Oh.
No. We travel in pairs now. That's how it
Oh.
works.
Oh.
Safety second.
Pair or a pack?
A pack, yes, a pack of two, wolf pack, yeah.
All right, Travis, you're up.
Yes, so, we kind of briefly touched on it earlier. There's discussions about how to use the opioid settlement funds, among other things, and one of the things that was brought to me was North Mason's desire to continue on with their psychiatric services up in the north end of the county, and they were wanting to discuss with the commissioners about ways that we could assist in keeping that program going, and so I thought, rather than the guy who knows the least about it presenting it, bring the ones who know the most. So here they are.
Awesome. Well, yeah, I think, Commissioner Tarswell might be a little bit newer, but we've got a chance to discuss the program. And, it started up north, and it started with a county partnership. It was, we wouldn't be sitting here talking if it wasn't a county partnership and working with public health. And, we had an opportunity to bring on a psychiatric ARP because we had stood up, and this is early in, I think, mid-23. We ended up standing up the Mobile Integrated Health Program, and we had our PA who was working, and he came to me, and I don't think it's a surprise to anybody in this room, but it said, hey, we're doing a lot of good stuff in the medical treatment provision and getting people away from 911 calls, but where he was struggling was in the mental health and psychiatric realm, substance use realm. And he had just said, hey, I dabble in this, they provide a little bit of background, but I'm a medical service provider, I'm not a psychiatric and a substance use service provider. And so, and just as he's saying that, we make that connection down at the law enforcement breakfast where, Christy, who is our psychiatric ARP, she ends up, her husband's in the audience. And I just love how small community connections work. You're at a breakfast, you're sharing a cup of coffee, eating some bacon, all of a sudden somebody pops up. But what was amazing was to have somebody with her credentialing, psychiatric ARP. They're unicorns, and they're even more rare in the fact that you take somebody that has that level of credentialing, but then is willing to work in the space of being out in the elements, working alongside the road, working in crisis, working in anything but an office setting, because that's essentially what she does. So It was gonna be a partnership with the county, and the county came back in '23 and just said, hey, and this was public health, just said, hey, one of the things, we probably don't have the opportunity, because this was actually gonna fold underneath Mason County Public Health. And Mason County Public Health was gonna be essentially the contract holder with the psychiatric ARP and make her available to the entire county. And there was a lot of programming changes going on with the health department at the time, and they had come back and just said, hey, we don't know if we have the ability to take this on, we're just swamped with a lot of things that are going on. And we knew that, we knew there was a lot of things moving at public health at the time. And so what we'd asked for was, hey, if there could be funding that came in, we would take on the contract and at least see, kind of in a pilot formula, how things work up north. And bring her on in a part-time capacity. We know we couldn't bring her on a full-time capacity, but to see how she was how her services would work up north. And she hit the ground running. And again, I know we hear the psychiatric piece. I think she does more substance use than she does psychiatric work. And so, and that's her area of expertise, is substance use. But generally those are co-occurring, right? You got the psychiatric piece that is co-occurring with the substance use. And so we worked up north. She's certainly working through the 911 system. I think one of the biggest eye-openers is how often she is used within our schools. And so a lot of the counselors, we go in at the beginning of our school year. We make a pitch as to the services that we provide through Mobile Integrated Health. And then and we make it the pitch to the counselors, to the principals, to the teachers that are at the school and whatnot. And then we watch the calls just flood. And the level of suicides that are happening, not happening, but that are on the verge of happening that we get called up for. Stuff that just really overwhelms what our counselors are really trained and designed to do within the schooling system. And so we ended up, we're thrilled with what she was doing up north, and then of course we had the opportunity to expand her services and then also step up the second team in the southern portion of Mason County. And so we were able to increase her hours. She was then working north and south. We knew this going in, that there would be a need in the south end of the county. We just didn't know it would be fivefold what it is in the north end of the county. The mental health and substance use challenges down here in the southern, certainly having the incorporated city, having a lot of the service centers here available in Shelton, folks gravitate towards here. And so, whereas that team, where our team up north took a little bit of hesitation kind of getting up and going and people aware of the services, not down here. It was day one. It shot out of the cannon, and it is, I wouldn't say difficult, I would say difficult keeping up. There's just a lot happening on both the medical side and the mental health side. So one of the things that has since expired was the county funding that was coming through treatment sales tax. And one of the things and the reason for the proposal is to hopefully continue the services ongoing. And so continuing the partnership that we do have with public health. We do know that that the opioid settlement funding is there, and I know in talking to some of my colleagues across the state, some counties are really having a difficulty understanding what is the biggest bang for the buck on those funds. And there's a lot of different ideas. It could be Narcan distribution. It could be prevention. And if you look through the list that the state has given, there's a massive, massive, massive list of things that those funds can be used for. But one of the things that we see, the psychiatric ARP piece being is, the fact that she's a hub to all the other services that are available in the county around those areas of substance use and psychiatric care. And so, but also to direct delivery of services, right? You have somebody that is in immediate need. There is somebody you can partner with in real time and have them walk through the system, or at least start the process and have them walk through the system, and that's what Christy provides. Again, she's a unicorn that she loves what she does. She's incredible at what she does and whatnot, and I'm hoping that the proposal is driven in a way that we would be able to keep those services in Mason County long term. So, and then you.
No, I would just add too that she continues to make herself available in different spaces. So she's working with the folks out of the jail as well. So she's able to go in there once a week. Really trying to work on that continuum of care. The folks that are out on the street and then they end up in the jail system. Is there a way to kind of capture them in there when we can get them on medication, when we can sustain that medication? And I don't think we can overemphasize the ability she has for her scope of being a prescriber, right? She can diagnose, prescribe, and administer medications. And the part she plays for mobile integrated health, I think, is super important. And it's really kind of at the center of the whole system, right? The behavioral health system and beyond. And so if we can continue to solidify what the core of that system is and then build out from there, I think we see the benefits. So, yeah, I think we called out in the proposal as well how it aligns with some of those funding options and some of the scope of what the state has set forth for opioid settlement. So it checks a lot of boxes. So.
How much were we doing through the treatment sales tax?
75,000.
How much?
75,000.
75?
Yep.
And you said that dried up?
Yes, and there was another 150,000 that will be set to dry up through opioid settlement funds. So it's those two funds together.
Okay, on the opioid settlement funds, that's something that we passed and put through?
Yep.
And,
It was 150,000.
okay.
Yeah.
And when is that scheduled to?
That will be done end of next year.
And that was 125.
150.
150 and 75.
75.
I've got some opinions I'll share with you.
Please, please, please,
Yeah.
yes, please.
We just had a conversation earlier about how we're gonna look at, what we're going to do to look at these monies and what to do with it. We're gonna bring Dave in, we're gonna start to talk about it. You already know, I'm already a fan of this, I always have been. What we did in the beginning with the full programs, we did seed money. And we did other monies to help keep it going, but fully funding it's always difficult. I know as we're looking at what to do with these funds, I have a personal view that I'm hoping the commissioner are gonna stay within it, because it's not sure what monies are coming in, when they're coming in, how much. I personally like 3-year windows instead of 5, because
Yes, yeah, sure.
this way you can control it, it comes back before us again, if we were to even do something like that. And again, these are only just my personal opinions. I always, as you know, love to hear and see what other options there are that you guys will be bringing to help fund it, instead of the county funding it completely.
Yeah.
So what that looks like in partnerships and what kind of dollars that comes up with. But for the most part, as you know, I love this type of stuff, and it's been very successful. Here in Shelton, I've been watching them with their critical person, and I have a feeling that person may not be around for right now, because all of a sudden things have changed quickly in the last month. And I don't know why. I haven't talked to the city to find out why, but it sure was obvious. And all of a sudden they're back on the streets and they're screaming on the corner, and
no.
I'll be
Okay.
curious to see why. But these are good things that you guys are doing. When the time comes that we are talking about it a little deeper, I'm supportive. But just know that personally, I like 3 years or less.
Yeah, sure, sure.
So that I can plan things, and I love to see other ways you guys are gonna be funding it and how it'll be self-sustainable.
Yeah.
Because it's almost impossible for us to continue to hold that up forever.
Yeah.
Just my opinion.
No, and that's very fair. One of the things that you'll be able to read, just came out actually on Thursday, is the state auditor actually, because when we think about Christie and her role, I mean, she's one microcosm of the larger mobile integrated health program, and that's where the partnerships kick in. You know, we've gotten money from Choice Regional Network, we've gotten it from Mason Public Hospital District #1 and #2. Our ACH, we've gotten several grants that have come in as well, and so there's other monies that are coming in for that overall. This would be for the psychiatric piece. One of the things that I was just saying that the state auditor's office just did essentially I don't know if it's a performance audit, but it just released an audit report on mobile integrated health programs in the state. And it is sitting there saying, hey, it's kind of cobbled together in different parts of the state. Some are more advanced than others. Yes, it has some great merit, and it puts some metrics to that. But no surprise, at the end of the report, it says the biggest issue is funding. Where is the funding? Now, I think we're the most advanced county in the county, or in the state, as far as the funding that we've woven together. But it's not long-term. And one of the things that we actually have a conversation on, and one of the things, I don't know if you have any pull on this, but we're meeting with our managed care organizations, our MCOs coming up on Friday. In fact, we're meeting with all 5 of them in Washington State. We've had some, the insurance companies don't know what to do with this, right? They sit there and they push back and they go, fire department doing what? We don't understand. And so we're credentialed with 12 insurance companies, the 12 largest insurance companies that people have for private insurance. And when we send out a bill for $200, we get then $12 back on that billing.
If
And we're like, if that, and we're like, what is going on? And they just don't realize the impacting. And the insurance companies are the biggest beneficiaries of the work that we're doing out there. I mean, outside of the patients are the biggest beneficiaries because of the outcomes that we're producing. But, you know, financially, the biggest beneficiaries are the insurance companies. And so what I would love to do is see them weigh in and say, hey, yes, how can we provide our share of funding? And that's coming up on Friday. So, Commissioner,
Well,
I'm right there with you.
Yeah, I thought, because I was gonna try
Yeah.
and put that connection with the insurance commissioner, but you were saying at the time, didn't really have to because you were working something with Mason County. Is that where this hiccup is coming, and it's still going through them, and that's how it's coming back,
No,
or
one
not
out.
Mason County, Mason General, sorry.
Mason, yeah, so Mason General was going to, they were a little bit different avenue. No, I like what the insurance companies do. Mason General's was taking advantage of our rural healthcare designation, something that we can't do on our own. And so because we are a rural community, we can get higher reimbursement rates through the insurance company. And I say we, the hospital can, we, the program, cannot. And so we were actually, and we are still looking at a relationship with the hospital district on how we almost kind of become a subcontractor with the hospital and then bill insurance companies and get a higher reimbursement rate. And that'll produce a decent amount of funding. It won't be self-sustaining. What is ultimately self-sustaining is our managed care organizations that do have significant funding for these type of programs saying, yes, we do see the benefit. And we want to make these available, and we will provide the funding for that. They have a lot of money to be able to do that. It's just, as we have found, we're not talking to the right people. We need to move up the ranks, and I think we're going to be talking to the right people on Friday. I'll be happy to report back. But at the same time, we've run into a lot of, hey, sounds great, and then there's nothing on the back end. There's just, there's a couple of squeeze balls and some pens that they hand us and say, hey, isn't that good enough for you? No, it's not.
And so, it's not for lack of effort that we haven't been able to get to a place of sustainable funding, and so I guess kind of where we're at is we, through the data, through the metrics, through the, even anecdotal, I think there's a ton of value in what we're doing, and so it's kind of one of those, help us until we can figure that out sustainably. Again, the biggest bang for your buck, I think, is mobile integrated health and for what it does for the community. So I don't think it's it's not a matter of us asking for forever funding, but if there's an opportunity while we're figuring it all out, and we, even if it's, potentially in the contract, hey, until you find, consistent funding or other funding, we can fund until that happens or something like that. But it's certainly something I think Chief can attest to that, we're not leaving any stone unturned and,
And I wasn't questioning that. I tell you what I'm saying what I'm saying, so that if there's an opportunity that arises, that you use the tool that you have in front of you to do the things and make the connections or make that piece happen, because if it's always gonna rely on this, it won't last because that money won't be there.
Yeah.
It
It's
does have
gotta-
an end date.
Yeah.
Yeah, absolutely does. Yes, it
And so with that, we have to find that other one, just know that you have the tools here, you already, I think, know it, and that's why I brought it up, not because I did the good job, I know better.
Yeah.
Commissioner?
In the same boat, yeah. I think it's a great program. Money's always a problem. Especially if you watched what just transpired right before you got here.
Oh, we came in late, huh?
Public defenders.
Oh, yes, yeah, we've been following that story closely, yeah. Yeah.
Yeah, the presentation you guys did at the yacht club was awesome,
Oh, thank you.
and such a solid team. I could be more proud that you guys are in Mason County. And so, I think you're paving the path forward. And so if we can, we gotta find a way to expand the services and make sure that they're safe, or safe funded, I
Yeah,
guess.
yeah.
So,
Thank you.
let's find ways,
Awesome.
yeah.
Thank you, appreciate it.
Yeah, and you guys are okay too.
You might be. Awesome. Anything else we can add or?
Watch for the next step.
Okay, perfect.
Yeah, and I guess along those lines, I would just, you know, encourage commission to, you know, keep the foot to the pedal on that. You know, as I was researching timelines for Mason County's settlement options, it's going on 2 years that we've had opportunities for those funding. You know, the conversation we had over at Public Health, that was over a year ago now. And so, you know, the money isn't intended to sit in the bank, right? It's not a savings account. So if there's an opportunity to even if it's not our program, you know, being somebody that's boots on the ground, that sees people suffering and going through what they're going through, if there's a way for us to get that money out, let's get that money out, please.
Well, it's funny, it's your request that kickstarted it. To
Oh.
Have them to be.
All of a sudden, things get in
Yeah,
motion, yeah.
Yeah, that's
of
what,
course.
because as it was presented to us, we have people that are requesting the funds, and now we need to figure out how we wanna to dole that out, so that's how that happened today.
Oh, gotcha, okay.
So,
Wow.
so yes, and I agree, the time is now, and as I said, I'll have my things on how I think that money should be expended out. I have no problem myself personally with looking at the ones that are already coming before us, and somebody wants to go out afterwards, but there's gonna be questions from the commission on whether they wanna go out for things and stuff.
Yeah.
And I don't blame them for that. I'm comfortable with what I see. I know two of them that I would love to see put in place. There's this one, there's the DARE program. I'd love to see, but again, at 3 years for me, because I'm.
Yeah, yes, right, sure,
I don't worry about the money and.
Yeah, of course, of course.
Okay.
Awesome.
Good.
Thank you.
Appreciate your time.
Appreciate the opportunity.
Thanks,
Thank you
guys.
so much.
Yeah.
Thank you for coming to visit us, Commissioner.
Had to work that in there, didn't you?
I did, I've been waiting.
Yeah.
Speaking
like,
of
wait a
that,
minute.
Chief, could I borrow Commissioner A for just a second?
Absolutely.
Go ahead and sit.
Yeah.
Yeah, there's something coming up right now, so.
Oh, yeah. Would you like to stay for a minute?
Never mind the bus backing up signal that you're.
Yeah, I was gonna say, both ways, or we,
It's just fine.
You could.
Yeah, no, have a seat.
Oh,
You're gonna wanna hear this.
is this for viewing pleasure?
Yeah, because he's a commissioner, so.
Oh, okay.
So I only had you stay because you are a commissioner on South Mason Fire, and yes. So the next item is mine. It's a request to put out a notice of public hearing. We received notification from South Mason Fire District that they had voted on the withdrawal of Squaxin Island tribal territory. And per RCW, when we get that notification from the fire district, we need to have a public hearing on that request. It requires a couple weeks of notifications in the newspaper and that process to go through. So we have attached a notice of public hearing that we wanted to set for October 28th. We would put that on the action agenda for tomorrow so that we could get that notification going. And that is our request at this time.
So Abe, on that, I noticed that the signature on there was your predecessor. So that vote came before you came in.
No, I think his is on it.
Signature, his
Yeah,
signature
mine
is
should
on
be
Was
there.
on there? I thought,
yeah.
Yep.
oh, okay. So on that, I thought the negotiations were still ongoing and you guys were meeting last week. What happened with,
They are, and we are. Yeah, they're happening concurrently. So one, yeah, they're not, one isn't necessarily determining the other. So as things move forward, we're continuing with the process. You know, at any point, we can make a decision one way or the other, but we felt that it was prudent for us to continue with this process at this time.
if you guys are still in negotiations, do you think it's prudent for us to have a hearing on it?
Yeah, we feel as though, I mean, they're connected, but they're also separate. So, we voted in our last, meeting to put forth this other resolution.
Okay.
And, we had a very productive meeting with, tribal council last week. And plans to continue, moving forward with, contract negotiations on that side, but this is also something we feel that we need to do as commissioners and as, for our district.
Okay.
And I think from our perspective, based on the RCW, once we receive that request from the Fire Commission, we're obligated to follow the next step in the process, which is to do the public hearing. However, that's the opportunity for you all to decide at that time whether or not you agree with that course of action or how we want to proceed at that time, and it's all spelled out in the
Well,
RCW.
I was saying with us, we need to have a discussion further about what exact powers and authorities that we have in this one. In my 13 years, this is my first one on that. issue.
Yeah, and it's actually spelled out in the RCW. I have gone and read the RCW. It's the opportunity for you to have a hearing. You can choose to not agree with the recommendations of the fire commission, if that is the choice.
So that is actually within our, that's.
It certainly is at that
I was in
point.
Hawaii,
if-
so I had my vacation when.
Yeah, at that point, if you make the determination that you don't agree with the fire commission, it would then go through a process where it goes out to a vote of the community members within that jurisdiction, so.
Interesting.
But at this point, we're obligated to follow the RCW to publish notice and to have that hearing.
And do you think time is of the essence, that you want it on tomorrow's to announce for that, or I just.
In order for us to follow our obligations, we should be doing this.
We had already prearranged with our folks to have that done tomorrow, just to keep the process rolling.
Okay. My gut's just telling me time is not, speeding things up on this is not a good move, but if that's what we think we're supposed to do, then we should do it, but,
Yeah.
okay.
Okay. Awesome, thank you.
Anything else?
No,
Thank you, Commissioner.
we do have something coming up on riparian projects, if you're.
Oh, yeah,
that.
perfect, perfect. Good.
See you, Commissioner.
Travis, thank you.
Yeah. Sure got paid you back for.
Do you have to bow before when you're walking down?
See you guys.
Good couple of guys right there, I'll
Yep.
tell you. Those are good people.
Okay, is Marissa here?
Yes.
Oh, there she is, all right. So, a while back, Marissa came to my office to talk about some of the work that they had been doing around the county and some of the things that they wanted to continue to do. So I asked her, I said, hey, if you have a couple minutes to actually come talk to the commission about.
Actually, it's been a while.
Yeah,
Since
it's
we've
been
had
quite a
somebody
while,
from this
so-
program.
I thought it would be a good time for her to come in and say, hey, this is what we're hoping to get done.
I'll introduce myself because I have met some of you, but not all of you. So I'm Marissa Newby, Riparian Program Coordinator with the Conservation District. I grew up in Mason County. Love it, best place. I've been at the district for almost 9 years. Started out on the restoration crew, working on many of these properties and these restoration projects, and have worked my way through to the planning, grant managing process stage. So with that, the projects that I have brought today is a proposed planting project on county property in the Skokomish Valley. It's about 12.6 acres of areas that are either lacking conifer cover or infested with invasive species, plant species that is. So there's invasive knotweed present on this property, or these two properties, and then Himalayan blackberry and reed canary grass as well. So I have a grant that would pay for the restoration of these properties, and the information that I guess I'm after today is if you guys know if there's anything with the titles of the property or anything that would prohibit restoration from happening on these properties, and then also if you guys
Never
are.
looked at them, so.
And also, if you guys are just okay with us carrying on and conducting restoration and potentially signing a landowner agreement in the near future.
I think what I would like to see is just us make sure that these properties don't have any restrictions or they don't have any, what's it called? Mitigation. And then 100% for it, but I just wanna make sure that we're not doing something that we shouldn't be doing.
Absolutely.
Yeah, I wonder if we got this because of flooding that occurred and somehow the county ended up with it, because it doesn't make sense that we would have it, so we kinda need to look at the property, look at the history and.
Absolutely, yeah. And that's the main reason I came today.
Yeah,
Yeah.
that's a great reason.
Just wanna make sure we're all good.
Yeah.
So, is it on here?
So do we have,
Do I have the exact property properties that are listed, or can you get those to me?
Yeah, the parcel numbers should be in the restoration plan that I sent over.
The plan,
I think
They're right here, if you can.
on the map.
Yeah, if you
Oh,
could
very top, okay,
blow it up a little
Yeah.
bit.
all right,
Yeah, and they're at the very top of the restoration plan as well.
got it.
Just
Well
below.
then,
Yeah.
I didn't know that that was a request for this, and so we can do a little digging to make sure that there's no issues that we can see on our end. And
Absolutely.
If not, we'll get back to you ASAP.
Sounds good.
Okay,
Cool.
yeah, for
And
sure.
you've got the grant for it, so that's
Absolutely.
awesome.
Yeah, we're all ready to go whenever, if it works out.
Right.
So, and I'm always available for questions, concerns, anything like that.
And is there a timeline on this? Like if you don't start planning tomorrow, nothing lives or something like that? I'm not a planner.
Yeah, no, as soon as possible, that way we have the grant under agreement right now, but there is I need a landowner certification form that I fill out, before we can do any sort of movement forward. So, but the grant is for the next 4 years, so it doesn't end until end of June 2029. So we've got some time, but,
Okay. But
sooner
not 2020.
would be better, yes, please.
Got it.
But yeah, so,
Okay.
Okay, awesome. Thank you. That's
right.
what we needed.
thank you so
Appreciate it.
much.
Thank you.
Pleasure to meet you.
Thanks for coming in.
Absolutely. Thanks for having me.
Yeah. Our pleasure.
You are next. You are next.
All right, good morning. So I have the long-awaited 2026 maintenance level budget as of today, September 29th.
Anticipated, highly anticipated.
Yes. So the estimated beginning fund balance at this time, and this could change, but the estimated beginning fund balance for 1/1 of '26 is $24 million in the general fund. So this is beginning with the general fund. The estimated total revenues in the general fund at this point for 2026 are $46,630,556 for a total revenue, including the beginning fund balance, of $70,630,556. For the salaries and benefits in the general fund, the estimate right now is $38,191,286. The estimated operating is $18,984,019. The estimated ending fund balance is $13,455,251. And that means that the total right now estimated to come from ending fund balance, the difference between beginning cash at 1/1/26 and ending cash at 12/31/26 is $10,544,749. And as a reminder, in 2025's budget, we ended with an ending fund balance or usage of our fund balance of $12,387,487. So at this point in time, we are looking better by almost $2 million than we were last year, but 2025, last year being 2025. In 2025, we had a couple of one-time expenditures, and this budget does not include those one-time expenditures, and those were approximately a little over $1 million. We had the REIT, transfer to REIT for the LATCF funds of $650,000, and then we had the increase for the one-time risk pool payment of approximately $400,000. So this budget does not include those items. This budget also does not include an increase to revenue, property tax revenue. It does not include a 1% increase, and it does not include a change in diversion. It still includes $1,080,000 that was what was adopted last year for diversion revenue coming from roads. So one other very small thing that I wanted to point out right now in the clerk's office. The clerk actually reduced his budget by $14,000 for legal notices in operating. So he had $15,000 budgeted there and reduced it to $1,000. No, I talked to him about it, and he is under the impression that the state is going to be picking up that expense starting in 2026, but I cannot find any legislative changes stating that, so I don't know if that was a
Even if they do
miscommunication.
though, would there be a revenue line
Right.
coming in if we
Yeah,
have
I'm
an
not sure
expenditure?
how that would work, so I'm thinking that might need to be changed, so, very small, overall, when we're talking about $70 million as opposed to 14,000, but in his budget, it's relatively small in the operating, so, it might be, an increase that we need to add, so, I'm gonna move on to the policy level requests, and I'm sorry, I didn't share my screen, so I'm gonna do that now. Okay, so moving on to the policy level requests for the general fund. We have total requests right now of $2,757,142. And I'll be sending out a more detailed version of the policy level requests by general fund and then by special funds. But right now, the policy level requests, that's what they are. And I also want to remind you that I have usually increased some of the the operating increases, operating expenditures for the budget in 2026. If those items are maintenance level, if I consider them maintenance level, if they are, contracts that have been signed or increases that, we're required to do by mandatory, by law. So just a reminder that this is not, the policy level requests are not the difference between 2025 and 2026 budget. So just wanted to state that. So the total difference between 2025's budget and 2026 proposed budget at this point in time for revenue is an increase of $2,413,839. When we take into account the beginning fund balance, sorry, it's a decrease of $186,161 because the beginning fund balance was estimated at $26,600,000 in 2025. And on the expenditures, the salaries and benefits are the proposed increase right now over 2025's budget is $624,403. And then the operating is a decrease right now of $53,302. And that is mainly due to the enterprise, the leases are a decrease of roughly $130,000 over last year's rates. So so that kind of drove that number down. We have a decrease of 1 FTE right now, and that's the temporary financial analyst that I had in my office for ARPA. And I'm going to go through and make sure that I have captured all of the FTEs again. I need to spend a little more time on that. Any questions or comments right now on this?
Are you gonna, put folders again?
Yes,
for each
I'll
commission?
do that, yeah.
Perfect.
The other comment would be, if you listen to what they were just proposing in public defense, can you look at that and see what kind of an increase that would be?
Yes.
I'm not sure that if we were to follow the recommendations that we would even get there.
There's no way.
I mean, I just don't see it.
Well, there were other requirements as well, not just for OPD, but there were also mental health assistants and so many.
Investigators.
Right, right, so it's not just the public defenders that we're required to look into.
Right.
It's a bunch of other
And support staff
positions as
and
well, yeah.
That's really.
Yeah, so when we look at the 10%, if we do the 10% per year, that's gonna be, the numbers that were given to us are gonna be different anyway, because of,
Well,
but,
yeah, completely different.
yeah. It's a lovely situation to be in.
We're gonna end up in some sort of hybrid version of it,
Yeah,
no matter what,
yeah,
because we can't implement the full, there's no attorneys.
no, well, and.
The cost to double what she's talking about.
Yeah, well, and then if you look at, because Kitsap County and King County, they put in the weighted system, but they didn't add the other positions that were also, so. It's a close one.
I don't see how we make this work at all. Anyway, something to think about.
Sure.
Just one more thing.
Just one more thing, Jen. Yes.
Okay, so I'm gonna move on to the special funds overview. So the special funds, for 2026, their beginning fund balances total, or estimated total is $63,638,394. Total revenues estimated are $62,262,952 for total revenues, including the estimated cash of $125,901,346. Total salary and benefit estimates for special funds for 2026, $16,339,698. Operating expenditures are estimated at $51,182,520. Ending fund balance is estimated at $58,379,128 for, again, total special fund expenditures, total budget of $125,901,346. And there are estimated budgeted FTEs of 132.91, and that's a decrease of 1.5 from last year, and that's due to a couple of positions in equipment rental and revolving. So we had the parts operator, the parts manager, forget what the official title is, but that position was not filled. And then they had a half-time shop assistant that we just hadn't filled that in years, but it continued to be budgeted, so they removed that from their budget this year. So, and again, I'll go through the FTEs for the special funds, just like the FTEs for the general fund, and make sure that I've captured everything in there. The policy level requests for the special funds, they do have some revenue policy level requests. The revenue is $1,960,054, And some of that is policy level because it's requested transfers in from the general fund. And I do have a change on this from the one that's in your packets. So I'll be giving that to Cammie and copies to you as well. So under the Community Services Health, I only had $100,000 as a request. And they've changed, I missed it. They had requested 2 other policy level requests. The total is $740,000. And of that, they're requesting an additional 505,000, I think it was, yeah, 505,000 transfer in from the general fund for a total of 605,000. And that would cover a vehicle and an FTE abatement, a code enforcement FTE, and a hearings examiner professional services increase. So anyway, and they also had 135,000 of grant revenue, and I put that as a PLR, and so did they, because it is a grant and it's requesting another FTE, so and a vehicle. So that's 135,000, and the departments are currently making appointments to meet with you to discuss their policy level requests. And that will be in October, starting next Monday during briefing. Yeah.
That's exciting.
Yeah. The total expenditure policy level requests for the special funds at this time total $5,893,700. So that is about all I have for you today. Are there any questions or comments at this point? I'll have a more robust presentation next Monday for you.
And we'll have extra time on the schedule, right?
Extra time? Would you like extra time?
For the budget?
Oh, yes, for sure, yes.
Yeah.
No questions.
Okay.
It's a great adventure.
Okay. Thank you.
Oh, thank you.
Commissioner.
A lot of work goes into this.
Sorry.
Yeah, just slam it.
Yeah.
And that's what you need about that.
Yes. Thank you.
Thank you.
Thanks, Jen.
All right, so we are running a little bit behind. We're scheduled for a break, but then to start TOPE at 12:15. Commissioners, how long of a break will you need?
17 years.
Not getting that one, sorry.
10 minutes? 5?
10-minute break?
10 minutes.
10 minute. We'll be back at 12, let's go for 12:40.
Okay.
You ready? Ready? All right. All right, we're back, everybody, and now we're gonna start with our TOPE workshop. What is TOPE?
It is.
I know, temporary outdoor.
Yeah, it's like,
events.
what does TOPE stand for? I don't remember. Yeah, temporary outdoor
test?
public event. Or private event.
All right.
Yes. Now, I was on Zoom earlier this morning, so I heard your zoning question. So I did bring copies of the, and I just did RR5, so the rural residential 5. But 5, 10, and 20 is essentially the same. So it's just the residential district in the rural areas, and that's really where the problematic, and Travis could have one if he wishes. The RR5 does allow, single-family residential. We do allow additional things as well. There's a limited number of uses. And then some things with a special use permit. And so when the office gets a complaint about someone operating an event we'll take the music festival as an example, and our staff looks into it, it's not allowed within the zoning. Now, one of the things you'll notice in their accessory use is cottage industry. So we did take that into consideration early on, like when we started work, prior to starting to work on TOPE amendments, we looked at the cottage industry section. I also brought you the cottage industry piece. This is also in our zoning, our development regulations under Title 1703. And so there are a variety of uses allowed as a cottage industry. So imagine you're a stay-at-home parent and you want to have some kids, so child care. So that could be a cottage industry where it doesn't change the look and feel of your residential house or neighborhood. Maybe you cut hair, maybe you're building products in your garage, that sort of thing. And we allow cottage industries, we encourage them, and they're allowed outright. We do review them. The planning department reviews, like if someone calls and requests, hey, I want to do this, that, or the other, can I do that? We kind of will look at it to see if it meets the criteria, such as the number of on-site parking, employees, etc., and those are listed 1 through 7. If you meet that and you're not exceeding any of that, you could just do it outright without any additional permitting. If it's something that exceeds, so sometimes people have a cottage industry but they exceed the on-site parking, or perhaps they're creating more traffic than what we would allow, then they have to go to get a special use permit. It's a public hearing with the county's hearing examiner. And so we considered that for these outdoor events, but because TOPE already existed, but at that 3,000 or 5,000 person level, we thought, for these events, it's probably best to just do it administratively, not have to do a special use permit with the hearing examiner, public hearing, all of that. If they meet certain criteria, we could look at TOPE, make some amendments to TOPE, and then that's where we get to today. So we thought it would be easier for folks to meet, to be allowed to do the public event, the outdoor events, through TOPE rather than through the cottage industry, which just the parking and traffic alone would cause them to have to do the special use permit. So you're looking at, depending on what fee, so say we charge a few $100s for a TOPE permit, as opposed to a few $1,000s for the hearing examiner plus special use permit cost combined. So it's a permit fee plus the hearing examiner fee, and that's around $4,000. It's over 4,000, but less than 5.
So Kell, a while back, this is what I'm gonna bring up, is what I talked about before. We look backwards, and it's not in there, it's not allowed, and we kind of disagreed on that a little bit, but that's what this comes down to. Where in here, and anything you just gave us, says that we have any authority to regulate that's not a business? If it's not a business, to regulate what they're doing on their private land?
I would say Euclid versus Ambler, 1926, the U.S. Supreme Court ruled that local jurisdictions have the ability to do zoning and restrict things on your private property. So private property is the ability to exclude others from your property. It's not the right to do whatever you want on your property.
And I understand that, and what I'm saying again though is different. For us, if somebody comes to me and says, this is illegal, the first thing I say, and I've said it to you over the years, show me the code that says that they can't do it. I still don't see a code that says they can't do it.
Well, I've been
If it's not a business, and it doesn't fit under these criteria as a business, I'd like to see where they can't do it. I agree if it's a business. I have no issue with that. I think that's where the biggest problem is for me, is I see some of these things get started where they have a full-out business and they're bringing people on there with the food trucks and everything else. There's no checking on them to make sure that they're safe. That's a different type of thing, but where do we have the right, just because we could create a law to do it, that's not what I'm asking you. I'm asking you, by our laws and our codes that we have now, where do we have the right to tell them now? Because if we're fixing it, there must be something showing me that there's something fixing. Does that make any sense?
I guess I don't understand from your perspective how, if I invite the public, this is not my friends and family. Friends and family, I mean, I have a lot of friends and family. I could get a couple hundred people over to my house this weekend. Probably not this weekend, short notice, but say a couple of months from now I have a party, and I've had parties on my property. There's nothing in our code that prevents me from doing that. But if I were to start selling tickets or...
That's different, that's business. I don't disagree with you on
So
that.
that's what we're talking about. So that's what I don't understand by your engaging in this back and forth. I don't understand, because there were two different folks that were here at one of the hearings that hold annual parties. And the public comes to them. There are they have personal strangers are coming to their place. They've paid money in one form or another to listen to music. And I think there's food vendors. I don't know. I've never attended one
There's
of
all
these
kinds of
things, so
stuff.
I don't know what's going on. My staff knows more than I do because they're the ones enforcing on it and know the details. But they were given money in order to, and provided entertainment. That was outside of their friends and
And
family.
again, I'm not disagreeing with that part, because
Well,
if it's a business.
That's what we're doing under TOPE.
Yeah, but no, from where we started, we've come a long way, but it's still, right now, there's still no defined on what it is that makes them.
I think I see what you're saying. So what you're asking is, like, point to which specific code section Jamie would write an infraction on for someone operating an event. That would be
Where is the
contract.
event listed in here as an allowed use?
See, that's what I'm saying, that's where I'm having a problem, and I've always had a problem, and I brought that up the last time we were talking, and I said that we do it that way, that if it's not on there, then it's not allowed, and you kind of disagreed with me on that day, and that's what I was saying, this is one of the problems we have.
I
with this
don't
system.
know whether or not I disagreed. Sometimes I have a difficult time following, so I may have misunderstood what you were trying to get at. I have worked here in Mason County for 15 years, with the majority of that time doing permit planning and land use planning, using these codes, which have not changed all that much since I started here in 2005. And I did have a gap in my employment here, but I have spent 15 years with this code, and I have been to the hearing examiner multiple times, different appeals, and I am not uncomfortable using our code as it is. And if the parties that we are enforcing on right now for not meeting the code, if they were to appeal that decision, so we're doing enforcement, they can appeal that and saying, hey, we have the right to do this. We could go do, it's called a Land Use Petition Act. They could appeal my decision. Actually, first, it would be an administrative decision that they would appeal. So they would appeal the decision that we're saying they can't do it. We'd go to the hearing examiner, and I'm very confident, and I would even consult with Tim Whitehead, I'm very confident that we would prevail by the way we establish and use our land use code. So it may feel awkward, but in my experience and using this, I'm very comfortable in Is it the greatest code I've ever used? Probably not, but it's not,
And
it's
Kell,
not.
you may be comfortable with it, but that's not what I'm saying. From the very beginning here, when we've had these discussions, the argument has been that if they wanna do something, they can't do it on their property because we don't have anything to allow for it. And what I'm saying to you is, show me where they can. I understand a business. If they want to open a business on these properties, I do believe that this code, because the way it's written, says they cannot do it there without going through these processes. It's all the other stuff that I'm wondering about. They already have an inherent use to use their property to the best the way they can. If they're not, we have restrictions on making money off it. I understand that, creating a business. But every other aspect of it, I believe they could have had these big parties if they wanted to. I'm not saying that it's right, I'm just saying there's nothing here that says they can't. Where that's how it was sold to us in the beginning, they couldn't do it. And by doing this, we will allow them to do it. I disagree with that. Now for a business, I see that. I see that here, because that we do go backwards on how we do it. If it's not an allowed use, it's a restricted use for business, but not for your personal use of your property. Otherwise, there's nothing on here that says that they can't have more than 3 garbage cans. There's nothing on here that says that they can't just park on any part of their property. We can't go back in there and say, well, no, we want to create something so that you can park there. That's what
Okay.
That's where I was running into the problem, and it took me a while to figure it out myself. It isn't that I expect you to have that answer. I wanted to meet with, me and Josh were gonna meet, but I went on vacation, and he was on his vacation first, I went on mine, so.
Well, the building code is almost not existent in these,
Oh, he
like,
just was gonna help me to put it in language we can all talk
oh,
about,
okay.
that's what he was gonna do.
Okay, but I guess maybe I'm personally confused then on your perception of a business, because my understanding is that Ian and my staff who have been enforcing on these groups, I think there's multiple, is there 2 or more? Or?
There's several, yeah.
There's several. They're all engaged in exchange of monies. So is that a business or not a business?
In my opinion, that would be a business.
Well, then that's what we're trying to do, is to allow that type of business to operate
Okay, if we set it
on a
up,
temporary basis.
okay, if we set it up that way, but understanding, because that's what I'm saying, it's been very weak on how it's structured, on what's wrong here. As we said, if it's political, we'll stay out of it. If it's, which I don't want us to even be in that question whether it's political. I don't want us to be questioned if it's a religious aspect. We have no business asking them any of that. Now, if there's profit being made and it's a business that they're trying to conduct on there, I can see where that fits within our code. And if we're just allowing a special use permit or allowance specifically for that, I understand that, and I can go along with that. It's just, that's where I think we have to draw the line. I don't think we have the right to tell them they can't have certain things in their property that's not business. That's.
I don't think we're engaged in any enforcement with anyone that
I'm not asking
is
about
not collecting
I'm not
money.
saying your enforcement, I'm saying by creating this, we're creating something. We're creating a restriction.
Actually, we're just
that
amending an
allows for it.
existing code that said you could have an event with 5,000 people. We're just reducing that number so you can have an event, a business event for any number of people.
Okay, well, you realize some of the discussions that we've had here, it was definitely not that simple. And what type of events, we were asking those different types of events and what types. Now, if we're talking strictly commercial, then we need to put that in there, commercial events.
So I just
But we're not, are we?
I want to adjust our perspective just a little bit. I definitely get where you're coming from with this. TOPE is not regulating anything. TOPE is creating a path so that if we get a complaint, someone can go down this path and they can get this permit. But TOPE is not, we're never going to cite something in TOPE and say you're in violation of X in TOPE and give them a fine, if that makes sense. There's nothing that we're creating in TOPE where we're gonna take someone to court over something that's in TOPE. It's all about the zoning regulation. So everything that would ever happen with, where we'd be going after someone would be within the zoning regulation or under public health if it's a public health issue. What TOPE does is creates a permit that someone can get. That's the only thing it's doing, is creating this permit. The county's saying, we will allow someone to get a permit to have this public event on their property.
Public commercial event.
Any public event that they, no, I hear you, but just bear with me for a second here. A public event, because people will play games all the time with whether they're charging for it or it's donations or whatever. Membership fees. There's all kinds of ways people will try to spin things. So this permit allows them to get a permit, because at the end of the day, let's say it's an event where they're not charging for it. If they're not charging for the event, they just say, we're having a rock concert on our property, it's free. There's no business, there's no transaction money, there's nothing. Let's say they're just having a rock concert. It's still a violation of the zoning code. Even if they're not doing it as a business, according to Kell's staff.
That's what I'm saying, show me that, that's what I'm asking. Show me
part-
that.
That's Kell's thing.
And see, that's where I'm having the problem, because by saying that, you're putting all this into a basket where they can be held accountable. That's what I'm asking, show me that, because I don't see that, and I haven't seen it when I was doing my own research.
That's a hypothetical, and I haven't seen that. So if someone said that because they were in a conversation, it's like, well, yeah, even if they didn't have money, they, because no one does that. If someone wanted to have a concert and they just invited everybody over, and it was a one and done, or you're just wealthy enough to do that and you love having strangers over to your property, I suppose I couldn't enforce anything on it, because it's not a business. It would just be like, I'm desperate, I want lots of friends, I'm gonna have free parties at my house for
I
people.
wouldn't go that.
No, I'm just saying.
I know, but that was pretty.
Because then I think you're correct. I don't know that we would have the ability to enforce on that, because it's like, what is this? Is this a free party?
Right.
But we're not talking about free parties. We're talking about people holding events where they're making money off it in one way or another, and it's not just friends and family, and they're having parties. I personally do not care one way or the other.
So then that's an enforcement decision then on your part.
Exactly. So when we get complaints on a party that's happening in a rural residential area where they're not, I'm going to say that if you and I, I'm betting on someone appealing my decision that we would enforce on this, that I would prevail. But I've been involved in a lot of appeals, and sometimes I'm wrong. It's been rare, but it has happened. It's rare.
So I want to step back then. So if you would not go after someone who would be charging for it, you'd say the code doesn't cover, someone is not charging for it if there's no commercial transaction whatsoever.
Yeah, because I just can't imagine that would actually happen, and if it did, then it's what's the difference between me having my friends and family? I don't charge them to come to my house, and so I can't prevent people from inviting people over that they don't know to their property and providing entertainment. So I would not enforce on that. So if I had staff that said that, maybe they, it's a hypothetical, and sometimes you answer hypotheticals in a way that's not real, because the real thing is not in front of you to then take seriously, think it through, because that's a waste of time. Every time we have to think things through at work, you're wasting time that you could be doing something else. So I don't like talking about hypotheticals at work.
Okay,
it's inefficient.
So that item aside, at the end of the day, TOPE is just creating a permit that someone can apply for. It's not an enforcement mechanism. There's no enforcement mechanism in TOPE. It's something that Kell's staff can say, oh, you want to have a concert and you want to have a rave party with live music and food vendors. Here's the permit you can get to do that. Because right now the zoning regulation says you can't do it.
And correct, because they're not, if they did it as a cottage industry, that's how we thought about it from the very beginning when Jamie and I talked about the enforcement issue. And we were talking about the cottage industry, they could go and get the special use permit because you're increasing the traffic and parking. So they could go get a special use permit. But I was like, we have this temporary outdoor public event ordinance that was passed in 2009. Nobody really knew about it because the folks who, when that was created, it's like everybody's kind of gone and no one's used it. And Oyster Fest gets that. They get that because they're a large event. So Oyster Fest gets that permit. And so I thought, that's much easier. That's way easier for these folks to go through that just get an administratively reviewed permit, rather than a special use permit, hearing examiner, public hearing, all your neighbors come out and get to weigh in on, what you should be doing. Where we're like, hey, these events, they're temporary, right? There's a few a year, and if they meet the criteria for, sanitary waste and solid waste and those kinds of issues, just kind of some basics, because you're having the public and they're paying you one way or the other to be there. Let's do it.
That is what it says, so Kell, in here. It does not say anything about whether they're paying for it or anything. It is very simple, and this is where the issue comes in. Definition: temporary outdoor public event shall be any temporary activity lasting more than 4 contiguous hours that is not designed or intended to be a permanent use of a structure or land it occupies. The rest is struck out. That's your full definition.
And that's so they can get a permit. It's not limiting them, it's saying they can get a permit.
When you can get a permit, you are being limited, and it will be limited. That's how we do things. If it's not specifically in our code, it is not allowed. That's what the problem keeps coming back to. So when you put that as your definition, if it's not in there as an exemption, then it's not allowed. That's what I'm saying. That's why I asked for these. This is what we're coming back to, and that's what bothers me about it. We can change some of that by making it for paid events and stuff like that, because I do think those are businesses, and I do think they have to be regulated, but I want to make sure that the rights of the individual are always protected and their ability to do it. And you may not be here tomorrow, you may not, I may not, they may not, it's the next one. And if they look at it the same way, and as you've heard in just this conversation here, we hear it differently, and we see it differently. That's why it has to be spelled out. If it's not spelled out, this type of confusion will happen. And somebody will be fined for it, somebody will be gone after for it, or harassed, or being told they have to buy a permit they don't have to buy.
So question, we had people come in and they talked about an event that was down the street from them, several weekends in a row, and it was different people all the time. So if there was to be an incident on there, let's say they got food poisoning, let's say there was a fire, let's say something happened on there, what is our recourse? How do we limit? Because, and they have neighbors too, so it's not just that property owner, but it's surrounding neighbors as well. Does this help prevent that?
It absolutely can help prevent that.
If they don't charge?
Regardless of what the situation is, if we have an event for them to get a permit, and someone says, all right, I wanna do this, whether I'm charging for it or not, I'm gonna get this permit. In the process of getting that permit, they're going to be educated on the best management practices for how to handle traffic, fire, sanitation, all those things. That's going to be
Right,
in
so
that.
those would be their guidelines.
Those would be their guidelines for that, for when they get that permit.
Okay,
So it
right.
would definitely help with that. If they don't have a permit and they're operating outside of that framework, they're doing whatever they think is good or not good, or whatever is the cheapest thing for them.
Right, Randy, I saw your hand go up. real quick.
Yeah, I think something that might be relevant to all of this is, right now, the fire code, as adopted by the state of Washington, no local amendments notwithstanding, specifically gives the fire code official, myself, the ability where if we determine that an indoor or outdoor gathering of people has an adverse impact on public safety through everything from diminished access to buildings, structures, fire hydrants, access, and the list goes on, that we have the ability to say, you shall put together a public safety plan. That's in the law right now. So if someone, let's say I got a phone call from Matt Wellinger out of, West Mason, on a Saturday night, he said, hey, I'm out here and it's a mess, you better come at her. So I go out there and I look around and he's right. I said, you're gonna have to cease this activity right now, and until you come back with a plan that demonstrates how you're gonna adequately address public safety. And the nice thing about this is that provides the mechanism to do that rather than find these things, you know, when they're in session, when they're causing a danger to the public and everyone else. You know, and that's existing law, and I've had to do it, not here, but in other jurisdictions, and it's not a pretty situation. It gets very confrontational. I've usually had to call law enforcement out to back me up because they obviously don't like what they're hearing, but it's in the interest of everybody there, including the people who are, you know, disputing the matter with me.
And I
So
know that
if they-
exists, you could close this place down.
So if they were to have an event and they were having fire shows during a fire ban, this would help them understand
Yeah.
that there's a fire ban and.
Very
it
much
should-
so. That's a very cut and dry example. I mean, the code it says where the fire code official determines, so it's giving me a tremendous amount of latitude, and the code by nature specifically doesn't get into specifics like that because they try and that gives more discretion and more ability for the fire code to work to come to some type of resolution with whoever it is out there, you know, or given the situation.
Sorry, Commissioner.
I was gonna say, so somebody gets the permit, they've done this, now they're having this event, they've charged money for, all those sorts of things, but they haven't followed those guidelines that you've laid out. Is that something that is, I think that's what I got from your question, is if they've gotten the permit, but they're not doing those things, is that something?
Yeah, if they've gotten the permit and they're not doing those things, then whatever portion that they're violating, we would probably try to do some technical assistance with them to say, hey, in your permit, you're required to do this, we've had reports that you're doing this other contrary thing, and bring them back into voluntary compliance. If not, we can do a permit, we can revoke their permit, and then at that point, they're operating an event without a permit, they're back to being in violation of the zoning code.
But this would give them the knowledge, the pre-knowledge,
Mhm.
that these are things that are required or prohibited. So,
Yeah, like, you gotta manage noise, traffic, you gotta have certain number of porta potties, you have to have a water source that's safe,
food
Or
trucks
have
that are safe.
bottled water,
or have bottled water.
Yeah.
or from the vendor.
But I do get your point, Commissioner Nevlin. You're coming at it from the, where does it tell me that I can't do that? Kell, as the director, has decided that the regulation gives her that authority. And when we get a complaint that someone's doing something, then she has to have her staff investigate that and enforce the code as their policies have determined. So that person is going to have a visit from Jamie saying, you're in violation of the code, you're at this event. I've got the information online where you're selling tickets for $83 each. And the event happened this date, there were noise complaints, there were sanitation issues, and then she's gonna take enforcement action against that person. That's how it's gonna happen. And when the person says, well, how do I do this right? Jamie's gonna say, we don't have a code that would allow you to do this on this property because you're zoning. So the only thing that TOPE does is say, here's a permit you can get. And the decision the commission is making is, are you going to allow these events to happen on rural residential properties, or are you not gonna allow them to happen? Right now, the commission does not allow them based on the codes that we have in Mason County.
They could get a cottage industry.
And I
Well,
think,
that's an option.
and I think that's incorrect. One of the things about me, I very much do not believe in administrative law. We make the code, we make the law, and then our laws are interpreted, put out there, but the administrator does not read a code that does not specifically say something, then hold somebody accountable to it. If we create this.
Are you
let
saying
me-
what,
let me-
I know,
let
but
me
if what
finish
he
this,
said
though.
about me?
It says in, no,
Oh.
it says in here that you have to have this in order to do it. So this is actually enforceable, because what it puts in, you will do this, this, and this. So it could be changed into something that would be enforceable, but.
Can you tell me, where does it say that they have to have this? Cause I don't.
Well, where it says that you can't have it, a valid county permit shall be obtained by the persons, corporation, organization, landowner, lease or allowance encouraging or organizing, conducting, permitting, and advertising a temporary outdoor public event. you know,
Wait, can you help me which page is that?
5.18.020.
Basic clause.
But there's more. Yeah.
And then on 060,
Yeah, there's more. That's why I'm saying, this is what I think it's incorrect that they can't do certain things. The business part, I do believe that that's not a stretch. I don't believe that's a stretch because we have what we call cottage industry or not cottage industry. They're businesses, just because they say it's not a business, if they're charging money, it's a business. That's just the way it is, and that, I think that is accepted through everything that we do. But some of these other things are not. We're stretching to say that that's what it would be. And that's where I don't believe an administrator should be doing that. That's us. We determine by putting it in there that a commercial event or something else should fall under this. That's how I see it. That's why I've always asked, even from all the beginning when we first were meeting, show me the code. Just show me the code. Where does it say? When somebody says they're being held accountable for something, show me the code. Then you show me the code, guess what? There's the code. That's the way it is.
If 020 is sounding kind of enforcement-y, that's not our intention. Kell and I went through the entire regulation and pulled out all the enforcement language. So if there are some changes that we can make to that to make you more comfortable with it, I think that our goal, and you can correct me if I'm wrong, Kell, but I think our goal with that section was to make it so that the person or whoever was involved with the event, a person from the event, could get a permit to do this.
And again,
versus
it's not
excluding
Kell
it
I'm
to-
afraid of. That's not the issue. I've been around here a long time. She is one of the most help you get to, yes, try to find a way to make it work people that, the only one that maybe come close is Jeremy Hicks, but Jeremy Hicks was pretty incredible at that. But
Wow, I'm flattered that I'm being compared to Jeremy, thank you.
Literally though, when it says shall, the next one, or somebody else, if they decide they want to enforce it, they can, and that's what I'm talking about, where they have the right to do these things anyway. If it's a business, I agree that they don't have a right to do it. And we made, I don't wanna beat you guys up on it, we just can disagree up here, I'm okay with that. I'm just telling you, that's where I'm running into it. These things are definitely a restriction on the people's ability to do things, maybe not by you today, but by somebody else tomorrow.
for me, just real quick, this is an event and not a commercial, business. Because these are temporary events, public temporary events, but to me, a cottage business is something that's there all the time. And so
Right.
this is something that's temporary, so I'm a little confused as to your definition of, because you keep going back to, it's their right there to have a business.
No,
But
not
this
right,
isn't-
not a right to have business, it's the opposite. I believe that our code and everything says they cannot have that business unless it fits within the cottage industry.
But this isn't a business.
It is, that's what I'm saying, I think they have the right to say that it's not allowed on that property if they're doing it as a business to make money or whatever. But if they're not doing it as a business, I think they have a right as a property owner, a right as a citizen to be able to utilize their property. Now, can it get to the point to where it's bad and they've got 100, 200 people there and they're in a bad safety location, then that's why we have that other law. To allow for that to come in because safety is an important aspect of it. We have to be able to protect the citizens when we see it. But creating a rule of law, and that's what this does.
Okay, well then in that,
before we lose that sentence, so when it says a valid county permit shall, if we change it to a valid permit may be obtained, if we,
can be
or
obtained.
can be obtained, would that make you more comfortable with that?
Yeah,
language?
well, I don't even mind the shall if it's for commercial. Now, the one guy that I like the most of all the people, I know he's going to be the one so mad at me at this because of what I'm saying. I know that. But the truth of the matter is that's what I'm afraid of. Not of his event, any event that has that many people trying to make money, doing it year after year to make money, bringing people on. We know that the food trucks may not have been inspected. We know there may not be a fire thing, and it's being done as a commercial enterprise that gets bigger and bigger and bigger every year. I don't like it, but I see a necessity to regulate such issues. I don't see a necessity to regulate everything else.
Okay, then we're on the same page, because I have no intention of regulating people doing what you want them to be allowed to do on their property. I agree with that. So it is only in the commercial nature of
Yes.
these things. So I
For
think
me.
we're okay. So then it's just a matter of, I think you should change to can. Like, this permit can be obtained
And-
if you need it for these commercial
But
purposes.
I was gonna say, and because we do.
But you don't have to.
And because we only, if it's not in there, it's against the law, against the rules, we need to put in there, commercial use, or some type of commercial definition if you're doing it, making money, or asking for membership, or include all that, I'm good with that.
Ian and I spent a lot of time, because initially we did, in some iterations of this, we had fees or something about them, money, but we just know all of the variety of ways people will try to avoid
I get it.
saying that they're collecting fees.
Then we can't legislate
And so we
stupid.
just kind of left that out of there, thinking, well, this way,
But in a system that says that if it's not in there, then you can't do it.
well,
That
I
doesn't
mean,
work.
it kind of
Believe me.
depends on the code. Each code is different, and so that's not always how, land use is very nuanced, and it's,
Well, and if you look at the difference between, I just typed in, what is the difference between a business and a temporary event? I mean, it's a commercial operation with a long-term purpose and infrastructure, while a temporary permit is a short-term specific occurrence like a festival or a concert designated for or designed for limited public participation in a defined period. So even that, you could put that definition in here, if you're looking for a definition between commercial and temporary.
Except for if I set up something, a food cart on something that's so commercial enterprise, even if I'm only there for 2 days.
But even that would be
That's all
kind
I'm
of
saying, it's just
in the
important to-
definition of cottage.
To define. Yeah, cottage industry is not set up for temporary,
No.
it's set up for,
So the definition right now that we have is the definition that is currently in the regulation. Kell and I stripped out an additional sentence in it that went into fees and durations and prearranged. There's a lot of language that was in that. So we simplified the definition, but the language that you had mentioned, or sorry, Commissioner Nidland had mentioned before was, that's an event lasting more than 4 contiguous hours that is not designed or intended to be a permanent use.
And is open to the public.
Yeah. Well, yeah, I was leaving out the part we added, but yeah, that and is open to the public. Because we added that little bit there to make up for part of what we had deleted for the second half of the definition.
There's something under,
Meeting with a Wasatch representative if it's the Amazon business.
all right, commissioners, how do you want to move forward?
Before we step off of that one, it's back to the basic clause. I have a little bit of heartburn over the, valid county shall or can, whatever.
I think it can.
Yeah, we can go either way on that. But prior to allowing, encouraging, organizing, conducting. Randy, let's get together and have a concert. Oh, I've just violated it because I just encouraged it. So, I mean, it's kind of goofy, but it's like, yeah, let's do that, Randy, and.
Yeah, and
it's
that's,
like,
and that's
uh-oh.
some of the original language. So if this is the kind of thing we need feedback about.
Yeah.
If you think that we should strip out,
Well, I'm not exactly sure how you word that, but I have a problem with that encouraging, because that becomes,
is a
it's a
strange-
really vague kind of.
yeah, and that's the original language. The original language has, they'll not allow, encourage, organize, conduct, permit, or cause to be advertised temporarily. That was when it was under the more enforcement-like framework.
But that was taken out.
That was taken out, well, under our proposal, that would be taken out. It's not taken out in current day code, it's in there. But that is our proposal to remove that, and we can further refine that by removing the whole prior part. The main thing that we need is, we need to know about if we're gonna, because this allows us to issue a permit, we can't issue a permit right now. If we're going to issue a permit, we need to know what they're doing and when they're doing it, and in enough time prior to the event in order for us to review the permit and issue the permit. Those are the things that we need just from a business standpoint. So,
Right, so if you're looking at the red line or the blue line, I guess, pages, those are all, that's what you'd like,
so we can,
or that's what we've discussed and you've taken out some of the things.
yeah, that's the thing that's lined through under 020 is what we deleted. And we kept a lot of it, but we removed the more enforcement language.
Okay.
We can further refine by getting rid of shall and put in can.
Right.
And if you want us to get rid of allowing, encouraging it, like I don't know if we need all those words in there.
All right, so page 108 of our packet
Probably not.
talks about, or shows the changes.
Yeah, it actually should be something more like prior to the event.
Yeah,
Yeah, doesn't need those words.
You know, the rest of this is like, well, you know, I just said, let's do it. Oh, I just encouraged it. Oh, yeah, you can do it on my place. I've just allowed it. You know, it gets really kind of dicey with those.
and again, you know, I think these are great changes, but at the end of the day also, no one is ever going to, because there's nothing built into here, no one's ever going to be able to, unless we further change the code, go and say, all right, I'm gonna write some infraction for 5.18.020 for violation of the basic clause because they, you know,
Yeah,
encouraged or
I
they
just
thought about it.
violated it.
Yeah, we're never gonna do that because there's no mechanism in the code to do that.
However, if they come and get the permit, at least, then fire will know, our police departments will know that there's something going on. So is there a process that we already have or currently have that lets law enforcement or our emergency responders, do we have anything in there that says, hey, this event is going on?
They would be part of the review process
Okay.
when a permit application happens.
Okay.
So they would be contacted, Public Works would be contacted, you know.
So probably to make that more precise would be something about, within, I'll pick a number, 15 days prior to the event or something. I don't know what the right number is, but
Yeah, I think we
have
have
it at
that,
14 days.
I think we have that that farther down where we say that the county will issue the permit within,
14 cumulative days, it's under your
That's- that's
5/18.
That's for the number of days per year that they can have. I think we have
Yeah.
60.
Oh,
we
yeah,
have
okay,
something,
got it.
yeah, I
Right.
can't remember what it was.
So
Too much.
Bed Bind is gonna be doing an Oktoberfest in Belfair, outside. That's what they do.
And they're
Commercial,
already allowed, because they're commercial where they're located, so they're a commercial zone, they're not in a residential
So
zone.
in commercial zone, there's something that says they're allowed to have outdoor events?
Well, I mean,
There's
they
actually
have-
There's something in the code that says they're allowed to have outdoor events at a commercial?
They have an outdoor
location?
space already,
No,
so.
this is the parking lot. This
Oh,
is not
okay.
that, yeah.
I
Yeah.
don't remember about that one specifically, but,
But how
one,
many other ones?
one that had been brought up was, I forget which commissioner brought it up, but, the fall festival thing that they have at, Hunter Farms.
Pumpkin
That-
chicken.
Yeah, that property, if you look at the zoning regulation for their agricultural zoning, it says they're allowed to have events and things that that pertain to like agricultural sales and other stuff like that.
So you're saying bent bind, not just their outdoor space on the side, but actual the
Right.
full thing? Then,
That's what they did last year.
yeah,
Again,
they're
I think
commercial.
we're
Yeah.
creating issues.
yeah,
so.
because it's.
Well,
private parking lot.
but I think but that's commercial, and this is not commercial.
But that, I mean,
This is
Randy's fire stuff would kick in for sure on that
On
one,
that one, yeah?
depending on how many people.
Yeah, regardless of,
Well, the city requires that, let's say Wild Irish has, they wanna take up the road, or something like that. They require a permit to do that so that
For the road
our emergency
closure.
responders are aware, and so the public is aware too. So I'm assuming that when commercial properties have something like that, which is different than this,
Right,
different classifications.
yeah.
All right, so do you want to make a couple revisions and then come back to us, or just on the wording?
well, I've taken out the whole prior to allowing, encouraging, organizing, conducting. So now it reads, a valid county permit can be obtained by any person, persons, corporation, organization, landowner, or lesser prior to the event. Each event type, as defined in this section, requires an individual permit. And that's, requires language makes sense because they can't get just one permit for a whole bunch of things. Because each event's gonna be different. So we're just saying that it's gonna be separate permits for those things. Responsibility for compliance and securing the necessary permits rest with all of those people that would be getting the permit. And that's just us saying that the person that gets the permit or who's running the event has to get the permit and then they have to comply with the permit.
Has to.
If,
Well,
sorry, I misspoke. The person that gets the permit has to comply with the requirements of the permit.
But you
That's
didn't-
the has
I was
to.
gonna say, but you didn't miss because it'll happen over and over and over and over again. That's what I'm trying to say. If the piece doesn't fit, quite often it's the wrong piece. So again, it isn't as simple as that. And we're not even, where are we saying in there that in our code now that they are gonna change our actual code, our zoning code to say that with this permit, they will be allowed to do it? Because that's what we're saying, the reason why they have to do this or can't do it or whatever is because it's not in there. So are we gonna change, as an allowed use in our zone?
I just wanna,
No,
so,
I get that it's not super simple, but we allow bulkheads on properties. There's nothing about bulkheads in here. So if someone went out, oh my gosh, they put a bulkhead on their property. Well, they got a permit. Well, what kind of permit? A substantial development permit, or a shoreline exemption rather. So it's a shoreline permit. So in this case, if we got a complaint and there's this temporary outdoor event, oh my gosh, that's violating the zoning code. No, they got the TOPE event under these circumstances and it allows them to do that here. Oh, okay. We know that's how it works. So
I know we have our.
so we're not,
building
we don't
permits for
need
everything.
to, we do not need to amend the zoning code to address all of the things that are allowed with other types of permits. Grading your driveway or whatever. I mean, all kinds of stuff. There's layers of, as you know, critical areas.
Yeah, remember, I did the planning commission for many years,
Shoreline.
and I can tell you that
Yeah,
there are the
building
requirements
codes.
of following the building codes, because it's an allowed use inside of it, so that's not an accurate way to say it. Either, if it's already in there now that they can't do it because it's in there, you have to change something in there that says they can to allow them to use it, or else it's not in there. That's what I'm saying, it's not actually in there. We're doing, somewhere, we're making an administrative decision that that's in there, and that's what we're doing.
I'm just unable to follow along.
at the end of the day, if we leave this meeting and Kell and I say, all right, I don't have any more time to spend on this, which we're getting to that point,
Definitely.
what's going to happen is the people that run these events, they're going to advertise their event, we're going to get complaints on them like we have, and instead of us saying, we're holding off on enforcement because we're trying to create some kind of thing that will allow them to be able to do this in a safe manner, that's not gonna exist. And Jamie's going to issue them fines, infractions, take them to court, go to the hearing examiner, and take enforcement action against them to prevent them from doing these events on their property. So if that is how the commission wants the county to treat those events, then the commission should just say, that's good, we're good with that. We don't want to make any changes to the regulation, we're good with having it be like that. But if the commission does not want us to do that and wants these events to be able to happen in the county, something needs to change. If this regulation is not the way you want to go with that, by all means tell us that. But you know, we've spent a lot of time and energy and effort on this. There are many other problems and things we can fix, and many regulations that need fixing. My list goes on forever, the amount of regulations that have issues in our county. So that's the bottom line. Next summer, there's gonna be a lot of enforcement action happening around events. Most of the events are done for the year, I believe, but that's, I don't know. What do you think? It's not meant to sound like a threat, it's just.
That's exactly what that was.
That
was exactly what that was.
It's not meant to sound like a threat, it's just, I'm just trying to say that that's what will occur because it's our job to enforce the code. And planning's position is that those events are currently a violation of the code.
And I did not take that as a threat. I took it as, this is what's gonna happen. It's not a threat, this is fact. So I didn't feel like it was a threat.
I did.
Well, that's one.
Yep.
And
What do you guys wanna do? Do you want them to proceed on this? Do you want them to stop? I'm fine with it. That's where I'm at. But I'm one of three.
I've pretty much come to the conclusion that I agree with you. There's probably some way to get to, yes, this is a way to get there.
mm-hmm.
I just had those small little changes I thought were a little bit vague. Or, caused some confusion to say.
Yeah.
Allowing, encouraging, organizing, let's be more precise in our language. I tend to agree that, I want to protect the people's right to do this, but if there's no way for that to happen, then let's find a way to make it happen.
Like I say, I agree with Commissioner Nunlin to some extent. If it's not clear in the zoning regulation, it's obviously not clear for you. I don't know what the process is for a zoning change or a zoning regulation change. I don't know how hard that is.
Well, if we're dealing with commercial, like I was talking about in the beginning, I can understand and that can be defined.
Mm-hmm.
If we're not dealing with commercial, we're dealing with everything else, that's a different story, and I don't support that. I can support commercial, I've said it 5 times at least, but I can't support putting this on other people, and if we have it so vague that if it's not in there, then it's enforceable, because it's not in there, that's how we do things. I've never liked it, but it is the way it is. Then it has to be in there. That's how we protect them. If it's not in there, they won't be protected.
So when you say in there, you're talking about early on in the regulation, you would like us to have in the temporary outdoor public event regulation, you would like us to say that
This applies to commercial events.
Yeah, I think that goes in the definition.
Yes.
It should be in the definition.
Okay.
Okay, I don't have a problem with that.
Because when it applies to commercial events, that means because it's not in there. the
Somehow
peop-
there's money
Define-
exchange.
and the
Define
people
commercial.
Yeah, and the people have the ability to do what they need to do for their own purpose. They wanna have a party, they wanna have a big wedding and have 500 people at their wedding, they're allowed to.
So
I know it says in the thing.
what
that
if
that's-
someone says we're a nonprofit?
That has nothing to do with it. Being nonprofit is nothing to do with profit, it just means your shareholders don't collect money.
Mhm.
That's all a nonprofit means. There's a
And
lot of profit in
I just
nonprofit.
bring that up because that
Because that
issue
gets,
gets used a lot
It does.
in discussions that we have where people say, oh, no, you don't get to touch me, I'm a
No,
nonprofit.
nonprofits have plenty of commercial activities.
So that is one aspect that we see a lot. But if we add to we have a big definition section, we have the temporary outdoor public event section, we have the second paragraph where it has such events can include but are not limited to and then it has a list of, we could say
Outdoor
such,
library
we could say such commercial events can include, but are not limited to, or is that still too?
Well, that would be helpful, but in that first definition, what this applies to commercial events, that the people inherently have the right to still have parties, weddings and stuff like that on their property.
So-
But for a commercial event, now, you might wanna put a thing, and any commercial event over 500, I'm not saying to do that, I'm just saying anything that would help to define it.
I've got a language suggestion. So we have, what if we say, shall be any temporary commercial activity lasting more than 4 contiguous hours?
I'm comfortable with that, I can support that. Now, like I said, those people in here are gonna be very angry at me, and I understand that, but I'm not doing this for or against them, I'm just trying to protect the citizens, because I do want them to have their food tested, I do want them to have their water, I want them to have a fire plan, especially if they're gonna do it to try and make money out of this thing, because it'll happen again and again and again, just like it has, I've watched them grow. I don't attend them, but they grow. I seen the video of one of them, and there was like 1,000 people there at
Yeah,
night,
they've been pretty
shooting
big.
off fireworks in a grass field.
During a burn ban.
Yeah, so believe me, that's not lost on me, it's just the rights of the individual, and I always want to protect against administrative law. Administrators don't make those determinations, we do.
I think we're all concerned with the rights of the individuals. So neighbors are included in that, in those.
I
that
agree
are
with that too.
Going down the road, so I think we're all concerned with that. But I feel like this is protecting and educating, I guess. These are some of the things that you need to make sure that your event, whatever it is.
Yeah, some of these things people are already doing, but other things they're gonna say, oh, I didn't think about that. But then they're one of those, oh crap moments as the event's happening and it's all falling apart because this one aspect wasn't.
And as we
wasn't
find
covered.
things that might be needed, we can always add them into something that's already been created, that's easier. And then we're strict on how we put it together.
Just getting the definition correct.
So are you comfortable if we make these final amendments, get it back out, and then see if we just put it on an action, if
Yes.
everybody says thumbs up, we'll
Yep.
put it on an action agenda to set another hearing?
No continuation of the other one, didn't we?
I can't
Yeah.
remember.
No, we didn't continue the hearing. No, we did
Yeah, we
continue the
did,
hearing.
because we
But not with a
purposely-
date.
But not with the date.
But not
Okay.
with a date, but we did continue it. This way we
Okay.
didn't have to redo it all again.
Okay, so then we could just, would it go on an action agenda to set the new continuation
No,
date? Or you just
just
set the continue,
Give
a public
For
hearing?
laughs, give them 2 weeks for the continuation date.
Okay,
At least that's my opinion, but
Yeah. Can you check and make sure that that's
Yes.
appropriate? Thank you.
allowable, okay,
because I don't even know that you have to advertise again. We
okay.
just continued.
Yeah, I'm not sure if we do or not. Cammy will check.
Cammy will check, okay.
And we left it open for them to still be able to come in and comment.
Yep.
Because they're gonna wanna comment.
Yeah.
Did not close public.
Right, okay.
Comment.
Public testimony is still open.
Yes, you
Yeah.
get temporary public, shall be any temporary commercial activity lasting more than 4 contiguous hours. Then somewhere you gotta define
The commercial.
Yeah.
what a commercial.
Yeah, okay,
event
that's what
is.
I wanted to work with Ian on that one, so we can include nonprofits.
Yeah, it's almost anything that's
Yes.
exchanging money, but there, I can visualize weddings where, the bride does a dance and they.
Oh, well, that's,
Yeah, with
yes,
There's
okay.
strange stuff, but
I get it, yeah.
And with that being said, I'd
Taking
love for
on-
us to send back to the planning commission at some point the idea of allowing for wedding venues inside rural residential, maybe over a certain acreage or something. Because
We allow wedding venues with the, yeah. we
There was
al-
one recently that I thought was done.
That was in the Skoke Valley, but the reason that one was originally prohibited, but then I removed it, is because it's in a floodway. And so, but because we're gonna remove that portion, that's another to be coming forward to you guys. Do you want me to talk about it now? 'Cause
No.
that's-
No.
Yeah.
I just
It's
think
so, yeah, we're gonna be removing a portion of the floodway in Skoke Valley.
that's interesting.
Not FEMA's floodway, the counties under frequently flooded areas.
Well, we had
Yeah,
It's
we'll bring that for further
complicated.
Well, I'm
discussion.
Further
another
discussion,
time.
but
I
anyway,
wonder
so.
if that's how we got that property that we were looking at today.
It's possible.
Because we did,
Yeah, but we'll
we
figure that
before
one
me.
out. We'll figure that one out.
We went after property before me. Those flood areas down there, the
Oh,
Richard
yeah.
Farm and stuff like that.
Oh, yeah, I mean,
Got
I think in the nineties, there was a lot of,
Yeah.
purchasing of property out there, that was in the
Yeah.
floodway, try to getting properties out of there.
They weren't allowed to even block up the river to stop it from taking away their property. Literally would take whole farms away, just the dirt gone.
All right.
Okay.
So, this is great.
Awesome.
Appreciate you guys. Thank you, Randy, for coming in. Yeah. Yeah.
Public hearing on September 30th, 2025 at 9:15.
September 30th?
That's tomorrow.
Yeah, we're canceling that one.
Yeah.
Oh, that was a TOPE
Oh,
public hearing?
yeah, was that it?
Originally.
No, I'm just looking back, it was Commissioner Netherland moved to table the proposed amendments
We did
to
set a
the
date.
law for 1 month, schedule a workshop
Oh.
for further discussion, and set a public hearing
All-
on September 30th.
All
at
we have to do is go back
9:15.
and put it off for another 2 weeks, it's not a problem.
Okay.
So we did do
All
it,
right.
I thought we
You
did,
said
but
Yeah.
Huh?
So tomorrow that'll happen
Okay.
in the action.
So
plan.
tomorrow we can,
Tomorrow, you
We
we'll
can set
say it's such and such a date, do we
Yeah.
wanna come up with a date?
we'll
For
put
2
2
weeks.
weeks, we'll put it 2 weeks out, that's all.
Okay.
Unless you need more time than
Is
that.
that October 14th?
Yeah.
Do you need more
I
time?
don't think so, I think we can.
we basically made the changes just now, we just need to meet. and
Unless
talk about it.
you're ready to move forward with it tomorrow.
No, but Kell and I have a meeting on Wednesday.
I'm exhausted, no, I'm kidding.
Because if you're willing, we could do it. But I thought we did because, I was thinking that we did because if you don't, then it dies, if you don't set a date. So I thought we did, but
Okay,
I thought I did too.
yeah, let's
Okay.
tomorrow just say the 14th, and then
Okay.
that way,
so we'll put it off for,
yeah, just cause,
but you'll open it and I'll just, well, you can allow for comment or you can, because I think we have to now. Just allow for them to have comments, a continuation, blah, blah, blah. Any comment,
Or
we're
we can
gonna,
just continue the
yeah,
comments until then too.
yeah, no problem, make that motion.
Okay. Okay,
yeah, so you may get some of the public to show up tomorrow.
yeah,
Oh, we will do.
maybe, especially
Okay.
after this discussion today.
Okay,
Okay. Commissioners, anything else?
Madam Chair, move we adjourn.
Second.
We're adjourned. Thank you, guys. Thank you,
Cool.
thank you, thank you.